your lordship's indulgence, can I be permitted to move in listed matter today?
Today? Is it so urgent?
My lord,
For today?
urgence in the sense the other day your lordship disposed of the matter. Regarding that, my lord, the supply of.
We can have it on Wednesday listed.
In the meantime, I have the
Some-
instruction
Something will happen.
from the post. They are going to.
Okay, please.
Oblige.
Yes, Your Lordship, my lord, I'd like to mention item 44, my lord. It has come in orders, my lord. Let this matter come after vacation, my lord.
44. Adjourn on the prayer of MS as per protocol.
My lord, there is another prayer. There are some analogous method that may also be listed along with this.
That judicial order we can pass only when we take up the matter.
Okay, then, I'm sorry,
At 10:30 is an administrative order only.
my lord. Oblige.
May I please, Your Honor, I beg to mention item number 18 and 45. I have taken consent from the other side. My lord. This matter, my lord, take up after vacation. My lord. Both
Adjourn on the prayer of Mr.
as has become.
S. Hazariya.
Time for a petition. So in item number 45, there is an interim order. Interim order may be considered.
We don't know.
There, it is there. my lord.
No, whether to continue or not, we don't know unless we look into the matter. You are for the respondent.
I am for the respondent.
Time for a petition.
What's the matter about? Why should it be continued? What is the case?
Lordship, matter is
Let the item be called. We'll see. One matter adjourn, other one will look into it. What is it?
Yes, my lord. The 18 is a new matter, my lord. That
18 is adjourned.
there is
40
no interim in that.
45, where interim to continue, we'll take up. We'll look
Fine.
into it.
Fine.
Yes, next item.
Oblige.
May I please, Your Lordship? Lordship, I beg to mention item number 6, Lordship, with a concern of others that kindly adjourn for their.
Your name?
D. Datta, Lordship, on behalf of H.L. Askar.
Is for the petitioner. The doctor petitioner. Yes, next.
May I please, Your Lordship? Your Lordship, item number 25, due to some personal urgency, my senior couldn't appear, so kindly attend the meeting. We have taken the consent of the
Your name?
R. Chaudhary. on behalf of-
Arthur.
May I please, your lordship, I beg to mention item number 3. We have consent from the other side.
Yes,
The matter will be.
your name?
A. Rahman.
Yes.
Item 1 for motion.
May I pray this matter may be taken on Friday night.
Item number 1. Adjourn on the prayer by myself. Elementary Education Department.
Item 2.
My lord, after filing of this matter, my lord, the name of the petitioner has been reconsidered by the DLC and rejected, my lord. So I may be allowed to withdraw this.
On the prayer of Mr. M. K. Sharma, petitioner allowed to withdraw the writ petition with liberty to file afresh.
Item 4.
Mr. G. Begu for the respondents.
This matter is into competitor department, lordship. The DLC Shipsago rejected, lordship, by order date 17 November 15, page 24, lordship. Yes, rejection. Page 24. Lordship, fifth line from the bottom, lordship. Lordship. The proposals of Mrs. Deepa Barua, Sangeeta, Dipjyoti, Vipul, Kamal Deka, Sri Ratul Deka, Diganta Satya, Niranjan, and Sri Vibhuti Go. This is petitioner, lordship.
Couldn't be
And so could not recommend due to lower percentage of marks of the HS examination in comparison to recommended ones. Further, the vacancies are not available for further recommendation. Here, lordship, this is a petitioner is a graduate, lordship. Lordship, kindly see.
Mr. Begu, who is appointed?
My lord.
Who is appointed?
Only one, my lord.
We have to state an appointment. Maybe after 8 years. How can you make a merit comparison in compassionate appointment? It's not a recruitment that who is more meritorious will give them. Who is this deputy commissioner? But why have come so late?
Lordship, the information was not informed Lordship, then I.
But what can we do now? We'll again issue notice. We cannot do anything. But otherwise, we'd have set aside the very first day, this order.
Last there was instructed to obtain the instruction. The second time it was.
What instruction we want? We don't want any instruction. We know it's per se illegal.
Yes, Lordship.
So we don't need any instruction for that. But what can you do after 8 years?
Lordship.
No, Mr. S.U. Ahmed. Some cases are there where somebody is not considered in a proper manner. We can remand and direct those matters to be reconsidered. But here is a case, it is a per se illegal consideration, which will require setting aside the recommendation of the man who had been recommended. But why it should be done after 8 years? So this ultimately has to be dismissed for delay in licence, this particular
Yes,
petition.
Lordship. Then when it was not informed Lordship, I have submitted application Lordship. And it's the phase 20.
But that will not change the circumstance. To give you the relief, we'll have to set aside the person who is recommended. He is now enjoying a work for the last 8 years. Why should we now interfere after 8 years? This is illegal, no doubt. You cannot do it.
Lordship, on 18th of February 22, Lordship, again my document is sought. And it's the phase 20. This document. When I approached Lordship, they intimated that my case was not considered. They asked me to submit.
No, it was considered and rejected.
That is 2015. Now Lordship, can it's the phase 20.
No. Why should it be sent back again?
No Lordship, that same DLC again sought my documents to resubmit.
Understand, the DLC cannot just play around with the people. Ask this deputy commissioner to come. Why he is doing all this? Mr. Pegu?
This is the DO, my lord, submission of document. Still going to have soft document.
But your deputy commissioner, is he conducting a recruitment process? Yes, see, could not be recommended due to lower percentage of marks obtained. So he's
Actually, the economic condition.
he is making a merit evaluation. So he's wrong.
It was he Mittal Lordship.
Whatever it is. But what relief can be granted? Other than setting aside, had you come in 2015-16, we would have straight away set aside this one. Means you cannot do it in this manner. But you have come after 8 years. What can we do?
But there's a communication between the.
Doesn't matter. Normal cases, communication helps you, but not in this case. Paragraph 35, Union of India versus Tarsem Singh. See, this has to be dismissed on that principle. It was anything. Union of India Tarsem Singh. Mhm. See, we are entertaining petitions even after 8 years, but those petitions are where somebody was not given a due consideration. We send it back to do that. But here is a case to give you the relief, we have to interfere with the recommended candidates. Otherwise, we cannot give you the relief.
Those
You have no point in arguing, Mr. Christopher. We have thought about you.
Only fair Lordship for direction to reconsider my
Oh,
case.
why?
Since
Before that, we have to set aside this order. How can we set aside?
maybe those are already selected by the SLC.
No, no. How do you know? You bring the information.
That is not.
You bring the information. On probability, we cannot do it. See, para 7. See, if the reopening of the issue would affect the settled rights of third parties, claim will not be entertained. Here we have to reopen the settled right of the third party.
leave it to Lordship.
You cannot leave it to us. We don't know. The petitioner receives the minutes of the DLC dated 7/11/2015. A prima facie illegality in the recommendation of the DLC is noticed that the DLC had ventured into a merit evaluation of the respective candidates rather than an inter-se financial comparison, which is against the principles of compassionate appointment. In compassionate appointment, the DLC is not sitting as a recruiting agency or a selection committee to make a merit evaluation. From such point of view, the recommendation is required to be set aside. Inasmuch as the recommended candidates were also recommended without following the due procedure of law. But however, the petition is filed after 8 years. From such point of view, the petitioner to explain as to why the writ petition should not be dismissed for delay in lashes, taking note of para 7 of the judgment of the Honorable Supreme Court in Union of India versus Tarsan Singh, reported in 2008, 8 SCC 648, wherein it is provided that if the grievance is in respect of any order or administrative decision which related to or affected several other parties, and if the reopening the issue would affect the settled right of the third parties, then the claim will not be entertained. This again.
Correct.
After 2 months.
Item 5.
Yeah, again. Section 5.
Please, Your Lordship.
DLC.
DLC.
Which page is the DLC? Yes, the district elementary review of Blogging shall apprise the court as to whether case was placed DLC for the second occasion. Order dated 4/4/2023.
My lord. We have filed our affidavit, my lord.
What is your stand? Was it placed or not?
47, my lord. The proposal of so-and-so petitioner is rejected as per.
No, we know that. Court wanted to know, was it placed for the second time? What's the answer?
Yes, my lord.
Placed. Placed for the second time. Where is the minutes of the second DLC?
Page 47 of our affidavit.
47.
DLC minor dated 5/4/2018. The 11% is page 47, my lord.
Name of the petitioner.
Is Porak Jyoti Gaon. Serial number 18, page 47 of our affidavit.
18. This is the second one.
Second one.
But court wanted to know whether you have placed it so that it can be considered against other administrative departments or any other post.
But
But you have rejected the pendency of 2 years.
my lord,
Suppose in the first occasion, you don't do the complete requirement of the law, keep it pending. You cannot take this stand. 2 years gone by. You cannot cover up your own lashes by taking recourse to 2 years.
considered in any other department.
Third MSSG Burwal and counsel for the petitioner also have Mr. Gurin Pigul, learned counsel for the deputy commissioner. Which place? district,
Jorhat.
Jorhat, and Mr. B. Kaushik for the Department of Education, Government of Assam. The father of the petitioner. CBS4 Gond was the headmaster of Khatwating LP School in the Jorhat district, died in harness on 11/11/2010. And on his death, the petitioner submitted an application for compassionate appointment on, what is the date?
My lord, the first application was placed immediately in 2011.
In the year 2011. Then was some more application,
It was rejected in the year 2012 on ground of no vacancy and no.
which was rejected in the year 2011 on the ground of no vacancy. Then you again submitted.
No qualification. Yes, my lord.
That was in 2011.
My lord, I have written in 2011, the government affidavit states that in 2012 it was rejected.
Okay, whatever it is, 2012. Then after that,
Thereafter, I reapplied again, my lord, which was not communicated to me. And after my communication, I applied again in 2017. I applied.
as the earlier rejection was not communicated petitioner, the petitioner submitted another application on
On my lord. In the year 2017, my lord.
next item. You check up the dates.
My lord.
Next item.
Item 7.
Get ready with the facts. Item 7.
Yeah, please, Your Honor. An advertisement was issued for the post of grade 4 science college Kukrajhar, my lord. Advertisement page 26, my lord.
Selection list.
Yes, my lord. Page 26 is the advertisement for filling up the post.
Notice heard Mr. S. Hazarika, learned counsel for the petitioner, also heard responding as IDBA. Just a minute. Who appears for BTC? Your name? Yes? Yes, borrow for respondent number 14. Authority is BTC. Do you know you have a higher education? For respondent number 2. Higher Education Department, Government of Assam. Mr. P. Sakia for 3. Directorate of Social Welfare, Government of Assam. Notice 6 weeks, extra copies 3 days, steps on 5/6, register post 3 days.
Obligement.
Item 8.
Kindly pass over for time being.
Item 9.
Compassionate appointment. Compassionate.
No, madam, not compassionate, madam. He was a contractual officer, madam, and he was terminated from his service, madam.
As to whether he was earlier appointed, or he was holding his civil post or not. Was he holding a civil post?
Last occasion, Lord, he was curious to know about it. Lord, he was curious to know about it.
Not curious. No one, court is never curious, Mr. Counsel.
He was asking.
It is for you to establish your own matter. Don't express those issues. Why should we be curious to know about your case? Don't use the proper expression, Mr. Bhuya. We don't appreciate this.
Sorry, madam. I'm sorry, madam.
You have to establish your legal right, and there we wanted to know, did you hold a civil post? Yes or no?
My lord, so far I had inquired as part of the Assam Education Service Rules 1980.
Education service rules.
Service rule of the
Which year?
82, Lordship.
1982.
82, Lordship.
Which page?
PS Lordship 698.
619. Six hundred and
698.
690.
698, Lordship.
698. Yes.
In exercise of powers conferred under the proviso to Article 309 of the Constitution of India, the Governor of Assam is.
Yeah, understand the rule is now which rule you are relying on?
309, whether civil post or not. Under Article 309, Lordship. 309 is Lordship.
No, you refer to rule. Now you are going to article. What provision you are relying on, Mr. Bhuiyan?
Constitution, Lordship.
See,
There is a question.
You have come before the court that your services were terminated without giving you a hearing. This is your case.
This is my case, madam.
We ask you, requirement of giving a hearing is Article 311 of the Constitution, which is applicable only when it is a civil post. So we wanted to know whether the post you are holding is a civil post or not. Please submit on that.
Super my knowledge is concerned, madam, it's a civil post.
Your knowledge is not the source of law, Mr. Bhuiyan.
Maybe wrong, madam.
You may not be wrong, but your knowledge is not a source of law. So you have to establish that the post, what post you are holding, that the post is a civil post, then you say what is a civil post. Please come prepared. This will not help you. Mr. Bhuiyan seeks for an adjournment to examine the aspect as to whether the post which the petitioner was holding from which he had been terminated was a civil post. Because otherwise, notice is not required.
Item 10.
Highly obliged, Your Lord.
Mr. Sharma. Yes, today respondent states in information with reference to the order dated 8/9. Heard Mr. P.R. Sharma, learned counsel for the petitioner. Also heard Mr. B. Kaushik, learned counsel for the respondents in the secondary elementary education department. Mr. P. Saikia for the Deputy Commissioner Lakhimpur. The father of the petitioner, Roman Gogoi, was an employee in the Phenkheti LP School, Lakhimpur, died in Hanes on 29/6/2014, and on his death, the petitioner submitted an application for compassionate appointment on, what is the date, Mr. Sharma? 11/9/2014. The grievance raised is that the said application was not placed before the DLC as required under the law. By our earlier order dated 8/9/2023, we required the respondents to provide the information to the court as to whether the said application was placed before the DLC, but in spite of another opportunity being given, no such information is made available. In the circumstance, as it is a requirement of law, we direct the District Elementary Education Officer Lakhimpur to place the application of the petitioner for a compassionate appointment before the next available DLC of Lakhimpur District. And the DLC, upon it being placed, shall give a due consideration as per the requirement of law. In the event it was earlier placed, no further requirement to place, but the petitioner be informed about the outcome of the same.
11.
DLC records we wanted. Huh?
Record is, they say the record is available.
Where?
In our office. They're coming. That's not, they have deposited.
Mr. Saikia, we cannot go to your office. Somebody will have to bring it to the court.
Record is a voluminous.
Sorry?
Can it be taken up after 1 week?
Voluminous. We are not frightened with voluminous records. Why don't you produce it?
Or after some time?
After some time.
12,
Yes, 12.
May please, Your Lordship. Matter is pertaining to compulsory appointment.
DLC, was it placed?
Lordship, in the year, Lordship, my application was forwarded. Next are case number 17, Lordship.
17.
Yes, Lordship. My application was forwarded by the Director of Elementary Education to the Secretary to the Government of Assam.
Why are you after 20 years?
I am still working as an honorary grateful employee.
Mr. Sekia, Mr. Koshi. This is a application of pre-Achut, what, Achut Ranjan? Even prior to that, 2003.
Used to be in a similar situation.
But there is no such a law. Yes. Place it. He wants to be placed.
23.
You reject it. Heard Mr. J. Hatimuria, the father of the petitioner, Bhaven Kapati, died in, who was a grade 4 employee in the Janata ME school, Dumuria, died in harness on 25/1/2000, and on his death, the petitioner submitted an application for compassionate appointment, which were forwarded by the Director of Elementary Education Assam to the Secretary to the Government of Assam in the Education Department by the communication dated 22/9/2023. In 2003, the grievance raised is that the said application was not placed before the DLC. You the limited grievance, the application be placed before the next available DLC of Lakhimpur district. And the DLC would be at liberty to pass any order as may deem appropriate in the facts and circumstances of that case.
The combination that is in the year 2003. Lordship.
item 13,
Please, Lordship.
Mm,
Sir, in the minor assistant professor of history, requesting
Assistant Professor.
professor of history, requesting police Karbi Angan, my lord. I have been put under suspension, my lord, under
Where is the order of suspension?
my lordship. The type 2 is page 26, my lord.
26. Any charge numbers?
No, my lord.
Nothing.
No. Only my lord, I have been suspended by the who is the not the authority to suspend, my lord.
He is not the authority. Why?
Because respondent to is my appointing authority. The respondent for us, my lord,
Who is the respondent to?
respondent is the director of education, my lord. Higher education, my lord, Assam. Director of Higher Education, Assam.
Who appears for Karbi Anglong Autonomous Council?
Yes.
Can we have him? Where is the order of appointment?
My lord, annexure 1 page, type office page 22.
22.
My name is at 5, my lord, bill number 5. Internal page 2.
Education is a transferred subject.
Well, up to higher secondary, not the higher.
Acha, up to higher secondary.
high-
Where is
up to-
that notification?
My lord, I do not have now right now, but anyway, in case of 6th Schedule area, up to class 12. that is
No,
higher
no.
secondary.
Can we take a look at it?
My lord. Anyway, my lord is appointed by the Director of Education, Higher Education.
Mr.
I have met
Savania, we
categories
cannot
that
go
will-
on a half-baked argument. No, if you were to pass an order, we have to justify our orders.
My
also.
lord, my lord.
Hmm.
My lord. I am
Please,
not bringing
please
that.
get that one.
My lord,
If it is not a transferred subject, of course, you are right.
my lord.
But first we have to take note also whether it's transferred or not. Constitution will not help you.
My lord, that which are subject to transferred, my lord, it is in there, my lord, rule 3.
Constitution mentions the transfer subject. I
My
don't
lord,
think so.
My lord, in 1995, my lord, they have
Are you sure?
amended, my lord, that is added, my lord.
Six schedule which clause?
Close 3.
Clause 3.
Otherwise, I'll get my lord in the,
No, no. Clause 3 is the power of the district council and regional council to make laws.
that will bottom, my lord, they have, my lord, in the note, my lord, after, they have how, which are subject are transferred to the
Hmm.
council is there, my lord.
Gotcha. This is not Kachar Autonomous Council.
Same thing, my lord, not Kasar and.
Kankari Anglo. We are not asking for your comment, Mr. Saranya. Is your case related to North Kachar Autonomous
No,
Council?
my lord, Karbi Anglong, my lord.
Karbi Anglo.
D, my lord.
No,
Primary and secondary education.
no, we have read it. But there must be a notification.
My
in
lord,
the transfer
notification is dear,
subject.
my lord, dear, my lord. It
Can
is,
you-
you will get,
can
my
you-
lord, in the 6th bill of BL Hunteria, my lord. That is there,
Notification.
notification is there.
Assign ye hoy kita. Okay, we'll get that book. Yes, what do you say? Who appears for the Karbi Anglong? Did you serve him a copy?
My lord, earlier it was listed, my lord, because they have appeared.
You have served a copy.
My copy, my name has been also shown, my lord.
Hmm.
For
higher education.
Kiman number item.
possibly, my lord,
13.
name has does not
Maybe
appear, my lord.
because of the list he is not coming. Wednesday list corridor. Wednesday
I did.
list Friday. List on so and so as paid for by showing the name of this the standing council for the Karbi Anglong Autonomous Council.
Hello.
Item 14.
Brr. See if he's available today
My lord.
after some time. We'll take
Well,
up.
well.
If he comes, we'll take
My
it up.
lord.
Item 14.
Yes,
My lord, this matter regarding compassionate appointment, my lord.
DLC, which page?
My lord, rejection of the DLC, my lord, page 21. And relevant portion, my lord, page 22, my lord.
No documents in support of was submitted. So what can be done?
My lord, actually, my lord, submitted, my lord, and I have also filed one writ petition also, my lord. In the meantime, my lord, and my certificate, my lord, after passing HSLC, my lord, I have submitted, my lord, certificate page, my lord, 16, my lord. My HSLC certificate.
No,
my lord,
no. Whether along with your application you had submitted the educational qualification or not, how do you know?
my lord, then, my lord, he was, my lord, reading in class 9, my lord.
Okay, later on you submitted.
Yes.
Yes, Mr. Saikia, what do you say?
Document have to be submitted along with the application. Document have to be submitted along with the application. On the basis of documentation, my lord.
But he says he acquired the qualification later on.
Subsequently, on the date of majority matter, he
Ah.
may submit it, my lord.
So, but you have to norms prevailing in the date of consideration.
Then my lord, he may submit it.
Hmm?
He may submit it, my lord.
He said he has submitted. Where is your communication by which you submitted?
My lord, this is, my lord, page 18, my lord.
18.
And in the meantime, my lord, I also filed one writ petition, my
No,
lord.
no, this is your application.
Yes, my lord.
Where is your communication by which you submitted your qualification certificates?
My lord, in along with this form, my lord, your education is written, my lord, HSDLED, my lord.
Hmm.
And WBC reference is also page 20, my lord. And my lord, rejected.
No, I know. But how do you know that whether you have details of this statement? How do you know whether you have filed these certificates or not? Suppose we have not filed,
Yes.
our order will be wrong. So we want to verify whether you have actually submitted or you have not submitted.
My lord, I also filed that writ petition, my lord. I have mentioned.
No, your mentioning is not an establishment of your fact. On which day, by which communication you submitted? Let us take a look at it. We'll pass the order, but we need that material before the court. The petitioner claims that although the DLC of Hailakandi in its meeting of 5/10/2021 had rejected his application for compassionate appointment as there was no supporting documents regarding educational qualification. But the petitioner, although at the time of submission of the application was not qualified, had subsequently acquired a qualification, and had communicated to the authorities regarding his educational qualification. The communication by which the educational qualifications were presented before the authorities be produced before the court. We'll allow it, but
If my lord submitted, may be considered. Diplomat.
Item 15.
what will they do with that order? Then you'll come in contempt after some time.
Yes. Diplomat.
Yes, Mr. Purokayester.
Maybe I'll take the lordship, my lord. I take a look at page 34, my lord. The petition seniority list of the school, my lord. The petitioner is Tonkeshwar Nath, my lord. He's senior to the private respondent at serial number 6, my lord, Jiten Chandra Borman. His graduate scale of pay, my lord, getting from 30/12/1993.
Yes,
and
secondary education department. Why did you make the junior man in charge?
the ground of
Kindly matter will be taken after.
After some time.
Item 16.
Last quarter instruction was sought for. The mayor pays some of them to things.
Sorry.
That will yet to be received. Yet we put some of them.
Where is SLC?
SLC pays base 25. Base 20, serial number 5. It is SLC is base 25. Serial number 3. Department, not
This is SLC.
SLC.
DLC recommended.
No, DLC also said, well, it is referred to the SLC, base 20.
Heard Mr. N. Hawk, Clearance Counsel for the petition also. The father of the petitioner, Bhupen Deka, was an assistant teacher in the Dhon Khundapara LP school in the Dorong district, died in harness on 25/2/2013, and on his death, the petitioner submitted an application for compassionate appointment on 25/2013. Admittedly, on the date of the application, the petitioner was a minor. And he subsequently attained majority on
39/2022, I filed subsequent.
and subsequently upon attaining majority, he submitted another application, bring it to the notice of the authorities
39.
by his application dated
39/2022.
39/2022. The application was considered by the DLC of which district?
10/10/2022.
Page number?
Page 20.
By the DLC of
Dorong.
Dorong district in its meeting of
10/10/2020.
10/10/2022. But as because the DLC found that there was a gap between the initial application and the subsequent application submitted after attaining majority, the matter was forwarded to the government for consideration. When the said view of the DLC was placed before the SLC in its meeting of
2/3/2023. Page 20.
the 2/3/2023, the following order was passed, page 25. The reading of the order of the SLC makes it discernible that neither the DLC nor the SLC had taken any decision on the application of the petitioner and had merely deferred their decisions. The law in respect of a late submission after attaining majority is has been laid down by the Supreme Court in its judgment in Khadim versus so-and-so. As a definite proposition has been laid down, it is for the DLC and SLC to consider the application as per the law laid down by the Supreme Court and not to give the matter deferred. Considering the above, the education department, the district elementary education officer, which district?
Dorong district.
Dorong district is directed to place both the applications of the petitioner before the next available DLC of Dorong district, and the DLC to take a decision on its own merit and not to keep it deferred by taking note of the proposition of law laid down by the Honorable Supreme Court in Khadim Supra.
17.
Yes, ma'am.
This matter relates to compassionate appointment, my lord. Here instruction was sought, my lord, for the last order. the petitioner case was rejected without assigning any reason, my lord, at page 27. My lord.
Records of the DLC. Records of the DLC.
Let me verify so many
Huh?
records. Regarding the Kovimbal district and Takra, my lord, so many records is available.
No, we want a record of this case. We don't want so many records
After some time.
after some time.
Item 19.
19.
Matter relating to academic in charge of the higher, Shimulbari higher.
Academic in charge of a higher secondary school. Principal.
Yes, Lordship. Lordship, petitioner was the graduate teacher, Lordship.
4 annexure 7, which page?
Annexure 7, Lordship, page 32, Lordship.
32. Mr. Education Department, will you here? What is academic in charge of a higher secondary school?
My lord,
Is somebody like a principal? There is no post called academic in charge.
actually, my lord, financial and academic is in charge headmaster. Sometimes academic are only given to the.
But whatever it is the otherwise it's the duty of a principal, I think. Whether you give full charge or a half charge or whatever it is, it's a duty of a principal.
Yes.
Who appoints a principal under the rules?
Direct.
Director. Does the school managing committee have any role in appointment of the principal?
School selection committee, my lord.
School selection committee is a totally different aspect. Does the school managing committee has any role in appointment of a principal?
The president of the school managing committee is in the school selection committee also.
Maybe. Committee is a totally different aspect and the individual is. Where is the appointment of principals? Which rule?
It is in 2018.
2018. Page number. Which page in this book?
Lordship, in my page, it is at page 34, Lord.
Same book, same color. The blue color.
Yes, Lord. This is
Page number 82,
page number 34.
34.
Recruitment to the post of vice principal and selection. It was regarding vice principal, Lord. Thereafter, rule 14, Lord. Recruitment to the post of headmaster, superintendent, and.
No, this is higher secondary school, not headmaster. Higher secondary or high school?
This
Higher
is,
secondary, HS.
Higher secondary, Lord. Page 32, Lord. Recruitment to
So it will be
and-
principal.
Yes, Lord. Rule 12, rule 12.
No, we'll make the appointment. Who is the appointing authority?
My lord, page 20, rule 2, my lord. Definitions. Appointing authority means director, secondary. education,
Director.
Assam University.
So I think only the director can do it. In charge, only the appointing authority can issue an order. It is done by somebody different. Heard Mr.
NH board.
N.H. Borvia, Learned Counsel for the petition, also heard Mr. U. Sharma, Learned Counsel for the Secondary Education Department. Don't you think this will be order without jurisdiction? SMDC does not have the power to make the in-charge principal who will be.
It is appointed by IS, my lord.
Even IS does not have that power. This has to be done by the director, whosoever he wants to give. Issue notice written was 6 weeks, extra copies 3 days. Steps on respondent number 5, raised a post 3 days.
Full load.
What happened?
Respondent number 4.
Why are you interfering in between? Please don't.
Sorry.
The petitioner is aggrieved by the order dated 4/4/2023 of the Inspector of Schools, Gwalpara, by which, as per the SMDC resolution number 1 dated 22/3/2023, the respondent number 4, Noni Gopal Karmakar, was allowed to be the academic in charge of the Simulbari Higher Secondary School. It is noticed that firstly, the order to act as the academic in charge of the school has to be understood to be an order allowing a person to be the in charge principal of a school, in as much as it is the duty of the principal of a school to be also the academic in charge of a higher secondary school. It is noticed that the order had been issued by the Inspector of Schools, and secondly, it is as per the resolution of the School Managing Committee. Under Rule 12 of the Assam Secondary Education Provincialized Schools Rules 2018, a principal of a school is to be appointed by the Director of Secondary Education Assam by following the procedure provided therein. Any order allowing a person to be an in-charge principal would also have to be made by the same appointing authority and not by authority who is below the appointing authority. In view of the prima facie case made out, the order dated 4/4/2023 shall remain state until further orders.
Item 20.
Yes.
I'm appearing on behalf of P9. He is on legs, Your Lordship. Kindly let me pass over for time being, Your Lordship. If you're pleased.
21.
Compassionate.
GLC rejected.
Page number.
Original page, Lordship, relevant page 35, Lordship.
35, number 1.
Serial number 1, Lordship.
Serial number?
Serial number 1, Lordship.
1.
Found that I have not submitted the fresh application, Lordship.
Where is the order of the court? 7/4/2016.
Case number 29.
Case 29, relevant case 29, Lordship. Last para, Lordship.
So if he had not filed, why was it placed before the DLC? Court said petitioner shall file fresh application along with and the DO, and in that event, DO shall place the case in the next DLC. If he had not filed application, why did you place?
Order submitted.
Sorry,
They have submitted perhaps honorable court order, case number 31.
where is your application?
Page 31, Lord. I have submitted. That was
Case number
acknowledged, Lord.
31, my lord. Submission of the order dated 7/4/2016 passed by the honorable Guwahati High Court.
No, he's not only submitted that. Your man must have read only the subject, not the contents of the letter. Letter is an application. I have passed BA, I have managed to as a great need for a job in public employment. This is an application for compassionate appointment.
Then district elementary education.
Sorry?
District elementary education officer name.
No. The district elementary education officer of Dhubri district to inform the court that if the order of the court was a conditional order, that only in the event of the petitioner filing a fresh application, the same to be placed before the DLC. Why without filing application, the same was placed, resulting in the order of the DLC that there was a non-compliance of the order dated 7/4/2016 of the court. Secondly, the application at page 31 itself gives an indication that it is an application seeking compassionate appointment, along with which the order of the court was also placed, meaning thereby the DLC may have misread the application by only looking at the subject matter that the petitioner had not submitted a fresh application. This Deputy Commissioner Dhubri to also explain the aforesaid situation. This for so and so for the explanation of the DO and as well as the explanation of the Deputy Commissioner.
22.
He must have made it. Your DC looked only at the heading. It did never bother to read the whole application.
Here, this is compassionate upon. My application was never considered before the DLC.
Mr. Sakya, place it. Oh, please. Heard Mr. Anand learn counsel for and what? And Anand learn counsel for the petitioner. The father of the petitioner, Lekhon Borua, who was an assistant teacher in the Ghormara ME school, died in harness on 4/2006, and on his death, the petitioner submitted an application for compassionate appointment on 29/8/2006. The grievance raised is that the said application was not placed before the DLC consent. In view of the grievance raised, this petition disposed of directing the district elementary education officer, Udalguri. Lakhimpur. Then why district is Udalguri? First page, why is the district Udalguri then? Come to the first page of your petition. Read on top. What do you mean by the first page of the petition? Repeat it. Next item. Yes, Mr.
May I please, Your Lordship? My lord, these are the persons, my lord, having the disability of wearing
Whether
impairment.
they were unaware of the disability assessment made by. Yes, medical examination report. Sorry, education department, huh? Huh? I live in maybe. Oh. Oh. এইবোৰ কেনেকে হ'ল গৈ তাৰমানে বেলেগৰ পিটিশ্যন বেলেগ মাৰিছে তেতিয়াহ'লে এইখনতো ভুল হৈ আছে ৰেজিষ্ট্ৰি ঘূৰি চাওকচোন মাতি ফালে এইখিনি কাগজ বেলেগ কেছৰ এইখিনি কাগজ বেলেগ কেছৰ এইখিনি ঠিকে আছে এবাৰ সুধকচোন ফাইলিঙত কি হৈছে তাৰমানে সুৰেন্দ্ৰ বৰাৰো একেটা প্ৰব্লেম কোনোবা দিনা We'll verify it. If this has happened, that means another application is suffering also somewhere. Yes, a medical report, Madam Fugan. Education Department to provide the result of the medical examination of disability after some time.
Item 24.
Sorry.
Admission into MBBS course, first semester.
MBBS.
Petitioner belongs to PGL ex-teacher category.
Huh.
Gets secured 417 marks in the NEET 2023, and he was selected.
So now, why have you come after 30 September?
My lord, they have issued the input note, cancelling the earlier he was selected. Kindly see page, my lord. Page 18. Personally, selection list, my lord, dated 3/9/2023, my lord. The petitioner was admitted, got admission, page 19. My lord. Medical College, Dibrugarh, my lord. Subsequent, my lord, on petitioner, my lord, Vishaka Chandra Vamshi, my lord, that appears before the court, my lord. And the petitioner, my lord, in part the order passed in the petition, my lord. The page 24, my lord, this is the admission notice dated 28/9/2023, whereby cancel the earlier selection, my lord. Second paragraph, my lord.
Why do you say whimsically cancel? Was the petitioner subjected to that committee? After the court order, we directed that every TGL application has to be placed before the committee.
Yes, ma'am. Now
it was placed or it was not placed?
Now, what happened, in compliance this court's order, they had issued the letter admission notice dated page 24, and it's similar. Their second paragraph, the admission notice dated dated 3/9/2023. That was cancelled.
Cancelled, very well.
Where in that list I was selected?
I know.
But
it was as per the court's order that every TGL applicant will be placed before the expert committee.
Now, my lord,
did the expert committee give any recommendation in your favor?
My lord, they are not verified, my lord. What happened, my
They
lord?
are not verified. Please don't say us.
Kindly see, kindly the list, revised list, publish along with this.
I know, reverse list, somebody else is given.
Yes, my lord, not my list. And lots of medical admission.
See, we'll verify the records of the expert committee. If we find that the expert committee, after hearing you, came to the conclusion that you are not a TGL candidate, after that you are still filing this application, we'll direct a criminal prosecution for fraud, committing fraud. You are agreeable? Okay, very well. Where is Mr. Gogoi? B. Gogoi? Ask let Mr. Gogoi come. And Mr. RM Das. RM Das is here. Just check up if he is around. Mr. Das, this petitioner Kuldeep Tasa, was he subjected to that committee after our order? Please verify from the records. Because he has come to the court now saying that I was initially admitted, now by the imperial order I am cancelled.
He might not be participated in the committee law.
No,
Because
no.
that committee has, the Director of Medical Education has already advertised, published an advertisement in the newspaper for all the candidates
To appear.
to appear.
So it is for him to appear or not to appear?
Yes. Yes.
What prevented you from appearing?
My lord, here-
See, there was a large scale fraud going on, which came to the notice of the court, that people who do not belong to TGL obtain certificate from TGL and tries to get a reserve seat. So it was as per our direction that the Director of Medical Education had issued a public notice that everybody is to go and appear before that expert committee. If you have not gone, it is to your detriment. Who prevented you from going? Because every other candidate went.
Yes, participated, those who are found genuine derivative. And lordship, medical admission after 13th September is
Not possible now. And forget about that. The petitioner, you examine
Petitioner
him.
is still well, doing classes.
How can you do class after cancellation? That is another false statement you are making. Mr. Hawk, it says,
For verification.
why should it be sent so casually?
No matter.
Somebody before the court go and verify it. It's nothing like that. You are given the opportunity earlier. It was for you to avail.
This imping notice was issued on 28/9.
We'll issue notice returnable 8 weeks.
They may verify, but can you on chance maybe given, otherwise it will affect the.
Suppose you are verified. Now, what kind of remedy can be given to you after 30th September? No, he's not studying. Seat has already been given to somebody else.
Yes, sir. Can you take it tomorrow, day after tomorrow?
Day after tomorrow. Yes.
Moreover, they have made party of the state level custody committee, but copy has not been served to us. So
Give a copy also. Give a copy to Mr. Das and you verify whether he actually appeared or he did not appear. If he had appeared, he can give us the report of the committee regarding this man.
that report is before the Lord's committee. I have already had it. In that case.
What does the report do? We will try to get the report. Day after tomorrow. Let's take it after on the prayer of Mr. Soft and counsel for the petition. But before doing anything else, tell us the name of your forefather who was a tea garden laborer and in which tea garden he worked. We'll get it verified. Tell us. To be a ex-tea garden laborer or tea garden laborer, somebody must have worked in a tea garden. So which father or forefather worked in a tea garden and in which tea garden?
In fact, well, the certificate was issued by the deputy commissioner.
We have seen the certificate. Certificate is genuine. But is the contents of the certificate right? That is the question. Yeah. Thursday. The petitioner to inform the court as to which forefather or predecessor of the petitioner had worked as a tea garden laborer and in which tea garden and during which period.
26.
BTC. What is this?
May I please? My lord, in the Travel Affairs Department in the Government of India, my lord, they have formulated a guideline, my lord, for the purpose of establishment of Ecologbo Model Residential School, a 10+2 school, my lord, in the tribal areas in the entire country. My lord.
Tribal areas in the entire country, or a particular category of school will be established. Okay,
Established under the, my lord, patronage of Ministry of Tribal Areas, Government of India.
very well. Huh.
And accordingly, my lord, basing on that policy, the Dolpari, my lord, Ecologbo Model Residential School in the district of Udalguri, in the district of Buxar, my lord, had been established and operating. My lord. Under the guideline, my lord, there are two level committees. One is the district level, and another is required to be constituted at the school level for the purpose of recruitment of the teachers, staff, and all the local administration. My lord,
First at the school level, then at the district level.
district level.
Yes.
My lord, may be pleased to find that at page, let us for a moment, page 55.
55.
My lord. Lord, I am referring to clause G. my lord. Page 55. my lord. Well, clause G, a management committee may be constituted for the each Ecologbo Model Residential School, which could include among the others reputed so and so, and may be taken up to organize socially relevant development so and so. The task of school administration, appointment of teachers, appointment of staff, personnel matters, and day-to-day running of the school would be handled entirely by the society, chosen by the state government and
Society means?
my lord, that the committee has been termed as a
No,
society.
management committee, ETRM include local NGO. Look, help us may organize socially relevant development welfare extension. Task of appointment of teacher, appointments day-to-day running will be handled entirely by the society chosen by the state government. So in your school, has the society has been chosen?
Yes, my lord, and that society has appointed us, my lord, by following the power exercised by clause G and H. My lord, may be pleased to find the credentials.
Where is the appointment of the society?
My lord, my lord, that has not been disputed, my lord. That original I have not annexed, my lord, in the petition.
And where is the appointment?
My lord, yes, my lord, at page 81, annexure 9 may be pleased to find, my lord, the entire list, my lord. This is the staff list, my lord, which had been appointed additional deputy commissioner.
Just a minute.
Page 81.
81.
My lord, annexure 9. And the petitioners are from this list before my lordship. All committee members have signed it.
Very well. No, that's why you wanted to see the constitution of the committee.
My lord, that committee initial constitution, we do not have the access, my lord, at this moment. But my
Anyway,
lord,
now what happened?
now,
Which
my lord, what has
advertisement
happened,
is?
my lord? This a proposal had been, my lord, advanced by the, my lord, for our absorption, my lord. That letter, my lord, may be pleased to find page 68, my lord. Page 68, my lord. My lord, this is a proposal from the deputy commissioner, who is the chairman of the district committee, my lord, advanced to the principal secretary of the Boruland Territorial Council. My lord, may can skip the first few pages. The relevant part is at page 70, clause 3, my lord.
What is the date of the selection? Page 81?
My lord, the page 81.
No date.
No date has not been earmarked, my lord. No. Initial appointment date. My lord, that till date we are working, my lord. It has not been disputed.
So now what is the grievance?
My lord, now what has happened, my lord, during the pendency of this proposal, my lord?
Which proposal?
The proposal at page, my lord, 68, my lord.
68 is not a proposal.
Advisory has been stopped from, my lord, that the what? My lord. My lord, clause 3, my lord, may I read, my lord, that page 70, my lord.
So what is wrong with page 68?
No, my lord, page 68, there is no wrong, my lord.
So
The wrong
where is your problem, Mr. Bhuya?
My lord,
Please
problem-
come straight to
Yes, yes, my
your,
lord. The problem is the advertisement which has been issued, my lord, may be pleased to find. by
which
which-
advertisement?
Yes, my lord, the advertisement for the new recruitment, my lord, at
Page number?
90, page 90.
90.
My lord. Now, my lord, in this advertisement, my lord, at the post in where we are have been now been working, my lord, we are, my lord, proposed to be replaced with a new incumbent. My lord, and the advertisement which has been issued, my lord, another contention is that this advertisement cannot be issued by the, my lord, member secretary committee for recruitment of the guest teacher. There is no any such committee, my lord.
Mr.
My lord.
Come to page 70.
My lord. Yes, my lord, page 70, my lord.
There are 32 teachers
Yes, my lord.
and 20 number of non-teacher. Mostly all teachers have B.Ed degree.
My lord.
However, few are CTET and ATET qualified.
My lord.
So possibly they find that the teachers who were appointed
My lord.
do not have the necessary qualification.
There is no any such finding, but no.
No,
any
number one.
communication has been made.
Number two,
My lord.
even if you go by this one,
My lord.
last paragraph, page 69, I would on as for discussion, meet once government shall ratify all decisions by the executive shall manage day-to-day affairs. During the handing over transition, there will be requirement of fund. As per discussion, an advertisement for a principal to run the school was highlighted would verify the qualification here. Would verify the qualification of teachers currently working in EMRS.
My lord.
So possibly after this verification, some of the appointed people were found to be not qualified.
My lord, but that they have not disclosed or no any speaking order has yet been.
But it is stated, page 70.
My lord, it is the.
So inspector is required to verify. Inspector must have verified.
My lord.
And after verifying, they come that most of the people may not be duly qualified.
My lord, without qualification.
See, Mr. Bhuya, it's not only the right of a person to be a teacher. Teacher is very sensitive. It is also the right of the students to be taught by a duly qualified person. So possibly if they're undertaking a procedure, they should let them bring an end to it.
Instruction. If that is the.
Otherwise, how can we impose upon the students, even if people are not duly qualified? Don't know, because once appointed, nothing can be done. And there again, we are put you one question in the very beginning. Where is the constitution of the
Committee.
number one? And number two,
Senior friend can obtain that constitution.
these are under the central government, these
My
schools.
lord, yes, my lord, this scheme is under the central government, but at present, my lord, in the state level managed by BTC, and my lord, the education is a subject, my lord.
These schools are not covered by sixth schedule also.
It has not been said
It
like-
cannot be because it's some central government scheme. Yes, Mr. Chotu, it is some central government scheme. to bring in residential schools in the tribal areas in the country.
Yes, Lordship.
Now, please come to page, I think it was. Where is that guideline you were referring
My lord,
earlier?
is page 52 Annexure 1.
50?
52 million.
52. No, initially you referred to
My lord,
something.
yes, my lord, that page number 55, clause G and H.
G, page number 55. Management committee may be considered by each AMRS, which would include amongst our local NGO. Task of school admission, appointment, teacher day-to-day would be handled entirely by the society chosen by the state government. Perhaps because of this one, somebody goes and makes a selection of these petitioners. Now tell us one thing. Are you involving the education department, government of India? Or it is only the tribal welfare department? No, why we're asking, tribal welfare can think about the welfare of the tribal people. They can bring in their scheme from their funds that, yes, we are going to establish some residential schools in the tribal areas so that the children of the tribal people are benefited, they are developed. For appointment and selection of teachers, can you leave it to the tribal welfare department? Because teacher selection is a it's a regulated process. Qualification, then right to education, then all various different kind of laws. And see, one society will select it now. Is the society competent to evaluate the qualification and eligibility of teachers? What is required under the law, what is not required under the law?
Lordship, this society may be that governing body or the executive committee that runs over the particular school.
See, no, even in Assam, the selection committee is by the, I think by now this by the higher secondary schools.
Yes.
Where is that? Mr. Chisti, I think that is your, by the higher secondary schools selection.
Yes.
But there again, elaborate procedure is provided. What is the qualification? How we will select them? What will be the constitution of the selection committee? Constituting people related to academics. They will make a selection, and not only that, it will ultimately be processed to the director of secondary education. Only then appointment comes. Now, if you hand over this responsibility to a society chosen, and who is that society? Some local NGOs. So will the standard of education be maintained? This is where we are a little concerned.
Lordship, I will try to get the instruction with regard to the guideline and the selection procedure or any guideline.
Something has to be there.
Something has to be there.
And possibly because of this, if you now come to page 68, that one, page 70, see the inspector would also verify the qualification of teachers currently working.
Yes.
Then whether they have CTET and ATET or not. Because these are requirements of a teacher.
Try to get.
Who appears for the Tribal Welfare Department, Government of India? You appear. What is your stand? You have to come a little this side, please.
Lordship, my senior is in ONLEX and
Who is your senior?
Ardhar. He is the standing counsel for tribal affairs.
Government of Assam.
Yes.
No, but this is the government of India. Sorry. I think this is a government of India scheme. It's all over the country. Can you send this to Mr. RKD Chaudhary? I think we need the central government to understand what is there. Right. Mr. Bhuya, after some, let Mr. RKD Chaudhary come. In other words, Mr. Bhuya, we are little concerned about quality teachers.
Hello, that is what the guideline says. RTE norms should follow while recruiting the teachers.
But it is done by some society.
That is not so.
To what extent the society will be competent to, the other day we came, see, whenever the issue becomes interdepartmental, the problem comes. The other day, it became interdepartmental with the labor department.
Yes, my lord, that.
Producing some notified labor department, somewhere teachers are sought to be recruited through a labor contractor by issuing tender. Now tribal welfare by some NGO somewhere. These other departments, they are not aware of the requirement of the education department. So I think it has to be done in conjunction. Otherwise, the quality of teacher, it will suffer. Oh. When will it be available? Wednesday?
Yes, he will be.
Wednesday, list Wednesday.
Item 27.
Yeah, what matter too?
26.
27.
But the service of the petitioner has not been provincialized, my lord, and the proposal is that page number 67, sent by the my lord district elementary officer Pathar.
67.
67 one. So directly sent to the DE Assam, my lord. It got to be sent through or DLS, the district level scrutiny committee, and therefore thereafter taking the approval of the district level scrutiny committee, it has to be processed. It is directly sent by.
For what purpose?
For the purpose of provincialization, my lord, the assistant teacher of the school.
How can he be provincialized on the retirement of Ilyas Ali?
No, he has been appointed in the year 2008, but his name was not my lord, forwarded.
Provincialization is always against the post to which the person is entitled.
Yes.
How can it be related to retirement of another person?
That is,
It cannot be provincialization.
like
After
that.
retirement,
Yeah.
that post has to be filled up by direct
Direct-
recruitment.
Yes, that is not the case.
So how can a direct recruitment be on the basis of application of Fazlur Rahman? Who is Fazlur Rahman? Petitioner.
Petitioner. He is a serving teacher, my lord, of the school, my lord. He has been appointed in the year 2008. But
You are for the?
For the SSI, Lordship. Here, Lordship, he was appointed in 2008-9, and his name
In a
was,
venture school.
venture.
and his name was enlisted in DICE code in 2019-20. Lordship. And he was appointed as additional teacher way back in 2008.
No, that is another factual aspect. What we are trying to understand is who is provincialized? A man is working in a venture school. Under the 2017 Act, individual cases for provincialization will be considered. If accepted, the man will be provincialized.
Yes.
And for this provincialization, I think posts are separately created. So, if this man is seeking provincialization, how can it be related to retirement of one person? Please come forward. I think you'll have to take a look at it. District Elementary Education Officer, Silchar. Is it not inconsistent? If somebody retired, that will be a post which has fallen vacant of retirement. It will be filled up by direct recruitment. If it is provincialization, it is not related to anybody else's post. This man will be provincialized if he is entitled. Then what kind of a communication is this one? Is it acceptable in the
This to be placed individually, independently before.
sorry, something is wrong. Something is drastically wrong. Either you will be provincialized,
Or no.
the DLC will recommend your name. If it is pending somewhere, we can direct them to
Yes.
complete it. If it is against due to retirement of Ilyas Ali, post held by Ilyas Ali will be filled up by direct recruitment. It's not a case of any provincialization. Now, your this communication is a hybrid of the two.
Yes, that is.
There cannot be any
that cannot
hybrid.
be valid.
And both are governed by two different sets of law.
Yes.
Provincialization law is different, direct recruitment law is different. How can both be combined into one? It cannot be. Something is wrong somewhere. The petitioner seeks for a direction that the process indicated in the communication dated 5/11/2020 of the District Elementary Education Officer, Kachar, be brought to its logical end. But a reading of the communication makes it radio communication gives an indication that an inconsistent situation is sought to be projected in the said communication. Petitioner claims that the communication pertains to the provincialization of the petitioners, but at the same time, the communication refers to filling up of certain posts which may fall vacant due to retirement of one Ilyas Ali. Provincialization would be governed by a set of law under the Act of 2017, whereas a direct recruitment upon vacancy having fallen on the retirement of a person would be governed by the law of recruitment through direct the procedure to be adopted for a direct recruitment. The District Elementary Education Officer Silchar to explain under what circumstance the communication dated 5/11/2020 was issued. Available as Annexure 6, page 67 of the writ petition. List on dated the DDO. Mr. SMT Chiefty takes note of the.
Item 28.
Retired, my lord, before provincialized. But the ultimately.
Still you cannot. Provincialization is your individual right,
Yes.
not subjected to somebody else's
I was
retirement.
independently appointed. That is.
DLC,
rejected, Lordship.
which page?
Original case, Lordship, 29, serial number 3.
29.
Found that 2 years have already expired. 2 years validity have already expired. That is the ground.
Serial number 3.
3, yes.
Anis Khurshid.
Yes, Lordship.
Was it earlier rejected?
Lordship, I have no other copy, Lordship.
Yes, Mr. Saikya. What do you say? The application for compassionate appointment of the petitioner stood rejected by the DLC of Dhubri district in its meeting of 22/9/2021, providing that 2 years validity had already expired. The relevant provision under the OM dated 1/6/2015 is that in the event an application was considered but could not be recommended for one top vacancy, and in the meantime 2 years pass by, in such event the application does not require any further consideration. The Deputy Commissioner Dhubri to explain as to by which earlier consideration the application of the petitioner could not be recommended for any want of vacancy. List of.
29.
Regarding area salary.
Area salary. Notice.
Kindly come to page 37.
So can I pass the order for area salary today itself? Notice. Your Ajad Ahmed. Ajad Ahmed, A. Fukan, Elementary Education Department. Who appears for finance? Where is A. Saliha? Mr. P. Saikia for Mr. H. Saliha for Finance Department, Mr. P. Saikia for Mr. Saikia, for whom do you appear? 9-2. GANA लिखी थी से H. Saliha for Finance, Mr. A. Fukan for Elementary Education Department. Notice 6 weeks, 6 weeks, please.
Item 30.
Mr. Bhuiyan,
Compassionate appointment.
DLC.
Not less.
No list. Yes, Mr. Saikia. Pass the same order. Jadhav Bosumutari, head teacher, Rampur, Bijoypur, Boro LP School, died 39/2005. Application for compassionate appointment. On what date it was filed? Application.
2/11/2009.
Hmm?
2/11/2009.
2/11/2009. Not placed, if placed.
Order stay vacating item 31.
In this matter, my affidavit is ready, man. Today I can file it.
Mr. P. Sakyal and counsel for Deputy Commissioner Goalpara
My lord.
states that the affidavit would be filed in course of the day. Pray allowed to file the affidavit within 7 days, this thereafter.
32 for admission.
Where is Mr. Kiel gone? He was here. You have the records with you.
We have received record. I think there is a vaccine code number 5.
They have brought the records. I can tell you verify them. Meantime, we will come.
Who will verify?
He will.
We will verify. We have no interest to verify any record going there. Time me. Let him come.
33.
Yes, here also we request, I think the government has provided.
Yes, sir.
Only thing we are thinking about the education of this child. Other day, somebody responded, Mr. Kial. Initially, Dr. Saraf, then Dr. Saraf was not available, then Mr. Kial also said. Because possibly the government doesn't have these schemes. If some private person is willing to come forward, we can appreciate that and record it in our order and close it.
Yes. Otherwise, whatever is available under the government, till the higher education, child can have.
And you also tell us what the government will give. Mr. Nath, you also tell us what the government will give. We'll record it And if some private person comes forward, we'll also record that and close
Yes.
this petition.
I'm told by my learned friend that the 4,000 rupees, it was given in the name of the father. Now father has died.
1,500 father.
Father has died. There is
Father
some
has died.
difficulty that will be sorted out.
Okay. What
Only
do you do?
some formalities may be required.
Hmm,
Death
hmm.
certificate of the person. may be required.
Understand.
We'll
List on some other day.
Lordship will list it after some day. After some time.
As paid for.
Intimate will take care.
Let's wait for list next week. Vacation. After
Vacation.
vacation.
After
In the meantime, confer with Mr. Kiel.
I'll-
Mr. Nath,
I'll-
you
I'll-
please
I'll-
take it up.
I'll talk.
Because he said that he'll look into the aspect.
Yes.
There is.
Lordship.
I see. Mr. Kiel,
No, no.
did you find somebody who can take care of this child education?
Yes, I got 2%.
Huh.
However, the amount may be communicated to the.
No amount, no, that whatever education. We are not quantifying anything. Like a guardian kind of a person who is ready to just to undertake the responsibility. And if he comes forward and tells us the name and with an affidavit, we'll put it a part of our order and close this petition. Please confirm it, Mr. Nath, because he's, if you correlate both of them, and government also tell us what maximum you can give, and we'll close this matter. Because this child, this mother will not be able to look after this child. Because the mother is hardly, how much about?
Now possibly 19. It is an expensive.
Mother, I think the mother is also still a minor. I think mother is still a minor, yet to attain majority. And this child is about 5 years old now.
5 years old, Your Honor.
Earlier. So that education period has started.
Provide the name of the school in which class is studying.
In which school the girl is studying, this child?
Anganwadi Center, Lordship.
Anganwadi Center is not a formal education.
Lordship.
It's not the formal.
Find out one school where this girl can be admitted.
They are easier, Jagirot, one private school, they told me.
No, don't go to any vague school. Where does the person reside?
Sonapur.
Santipur, Your Honor.
Where is Santipur?
Khetri, near Khetri, the remote area, Your Honor, Lordship.
Which is with the best. Otherwise, had everything would have been all right with this family, in which school the child would have gone? Suppose all this event would not have taken place, in which school this child would have gone?
Lordship,
You think it from that point of view. That's the best way.
Information is provided, I can talk in
This person, whosoever is coming forward, will appreciate his gesture, and he can bob some kind of a fund somewhere, and from that fund, the education will be paid.
All of them, in some cases, they are making payment to the school directly.
I can. That is even better. Take it up with the school concerned, pay it directly, and the school will give education to you. And the next stage will come with a higher education. There possibly something more will be required.
Even that can be also arranged.
We don't expect that sent to Oxford or Harvard or something like that. But something normal, reasonable.
Reasonable.
Let my lender friend provide all the information.
We provide the
Lordship, I will provide.
best is what? Three of you correlated with each other and tell us in a substantive way, we'll put it in our order. I think that is best.
That will be better.
And Mr. Kiel, thank you for the gesture of yours. That's a good gesture. As patron, we are fixing it immediately after the vacation. We'll pass the order. 9th November. 9th November. We'll pass our order on that day. And please coordinate. That's the only way out. Otherwise, we can do anything. And government also say how much maximum is possible under the existing regulations.
Lordship, I'll inform. Whatever has been given and how much can be given.
More can be given. Thank you.
34.
TGL. Some TGL matter.
Yes, Your Lordship. So Navodaya Vidyalaya Samiti admission matters, Your Lordship. Your Lordship asked us to wait subject
Huh.
to what Mr. Das has to say about the matter.
I think these people can also be subjected to the same committee. The committee will decide as to which forefather was a tea garden laborer.
Correct.
If it is yes, you clear it, then the admission will be confirmed. If it is no, it has to be given to the next man waiting. But it has to be done within the time limit, because otherwise it's a matter of a school session is there. The petitioner to appear before the
State level caste scrutiny committee.
state level caste scrutiny committee under the Social Justice Department. Some date, we fixed it up or
Lordship may fix a date.
Uh,
Because then it becomes easier all around.
you tell us the date, you confirm the authority, tell us the date on so and so at 10:30 a.m. and with all relevant materials and documents as the petitioner may like to rely upon. The committee shall determine as to which forefather of the petitioner had worked as a tea garden laborer in which tea garden and for which period. And thereafter submit a report before the court. List on so and so for the report.
Lordship just fixing a date for the report.
Date now, it will be have to go after the vacation.
Immediately after the vacation, because the
Immediately.
children will also suffer.
Definitely,
Do not
we
want that.
understand that. Will it be possible before the vacation?
I,
I think even Humbar.
nine. No, we have till 19. Nine.
On the first day. First day of the reopening.
Six.
See, if you can convince Mr. Das, we don't mind. We are here.
19th, I was.
But we'll
asking
need
the
only the
welfare.
report. Without the
But then
report, it will be
18th is
futile.
starting before perhaps the
Understand. And
offices might be closed.
Her apprehension is also right, because it's a matter of school education. More the session goes ahead, the more difficult will be for everyone.
That is correct.
Okay, list on so and so for the report.
Lordships,
And
two petitioners in this petition.
both,
both
both the petitions.
Then in
And
the
you
next-
give the date after conferring with your officer, and we'll put that date.
If I have confirmed with it, there is two petition Lordship. Petition number one is the in the clause 24 level, and petition number two is
Patwa.
Lordship, is serial number Lordship.
Then who asked you to file a joint petition? Why are you misjoinder of cause of action? Petition dismissed.
Lordships, perhaps not.
See, common petition, only when we can pass only one order, it will cover everybody. But if you have to pass two different orders, it cannot be a joint petition. It always has to be a separate petition. Anyway, what is the second one?
Lordships, the next writ petition, the item number 35.
No, he says the two petitioners.
Two petitioners, Lordships. So number one is the one under challenge.
The-
As per
the-
our.
one is clause 24.
One is close.
And
As
the
per
other one?
Our understanding, Your Lordships, the other one is eligible as per whatever was, we were scrutinizing the documents as per the
If
earlier.
it
orders.
eligible,
But let them, both of them appear, Lordships, now that Your Lordships have passed a detailed order
Yeah.
on 17.
No, no, second one is not TGL. Second one belongs to under which clause? Huh?
It belongs to Mukhi.
Mukhi.
Mukhi Lordship. Serial number 15.
No, no, please. No, not this. Okay, so Mukhi is a separate entry. And who will determine whether it is Mukhi or not? Mr. Das? Who will determine whether the person is Mukhi or not? Same committee. As regards petitioner number 2, the committee shall determine whether the petitioner belongs to the Mukhi community with reference to clause 15 of the OBC notification. But for Mukhi, if the certificates are genuine, we have no difficulty in accepting it. Only difficulty was with this TGL, because the complete inquiry was not made.
In fact, that is what we have stated in an affidavit, that so far as the petitioner number 2 is concerned, so far as whatever we were documents he has produced, as per our understanding, they are perfect and he should be allowed to give admission. In fact, we have also, because there is an interim order, so therefore we had given provisional admission to the child.
Okay.
He is studying.
So you also go to the committee.
But let him, since he's there.
I think you clear yourself before the committee, we'll pass the order.
Item 35.
Lordship, same similar matter. Here there are 9 petitioners, Your Lordship,
See, all the petitioners to appear before the committee
with all the documents.
with their respective document. Everybody TGL? Are all of them TGL or someone
No,
different?
yes, all of them are TGL.
TGL.
All of them are
Take only Harry. First part to the to deal in that one. TGL.
Lordship, there's one more prayer before Your Lordship. Another item which got delisted from these 2, similar matter, it was listed before Justice, Honorable Justice N. Silo today as item number 34. We made a mention before the Honorable Court, and the Honorable Court has passed an order today saying that it should be listed with along with these 2 matters. If I give you Lordship the writ petition number, perhaps an order might be, because then those students would otherwise, there are 12 petitioners in that petition.
Tomorrow we can pass the same order. As the committee will be sitting, you consider everyone.
The writ petition is item 34 before Justice Silo's court today. The writ petition number was 3975 of 2023.
No,
That I'm.
no, what we can do based
Perhaps it
upon
can be
the
taken up
order
tomorrow.
passed by Justice Silo, we'll ask the registry to take note of it and list it tomorrow. We can't pass any order.
Absolutely, that's what I wanted to make it, so perhaps it can be taken up tomorrow.
Give a mention memo tomorrow.
Tomorrow morning.
We'll list it day after tomorrow. Because by today the order will be signed.
Correct.
Based on that you can give.
So then my learned friend will apprise your lordships about the date on which we have to appear. The students will have to.
Ask them, say there about 15-20 of these people will be coming or maybe a little more.
Maybe they can appear immediately post Puja, your lordships. No? So mera date will be
And we have time up to November, I think. So do all the cases in the meantime.
I'll make a mention tomorrow.
Thanks.
Deeply appreciated.
Item 36.
Yes, Mr. Bora.
The last occasion, your lordship, the directed the respondents to whether the petitioner is covered under 311 of the article. Challenge the termination order as well as the director order matter.
Where is the termination?
Pays for Patti minor by putting the stigma minor. So thereby challenge for lordship. 2 order. First order is passed by the school management committee on 12/8/2015 minor.
Same, I think in the morning also one matter came up. Mr. D. Bhuya. These contractual teachers, are they holding a civil post?
But by this honorable court minor, regarding contextual purpose, there has to be the proper procedure met by this honorable court. My Lord Justice, regarding the by putting stigma, there are 16 minor contextual appointment petitioner. There are 16.
No, there is a difference, Mr. Bora. We are aware of this order.
I am in the context. I'm
Mr. Bora,
my Lord.
let us point out the difference.
X is different, but the issue is my Lord same. My Lord is I am the contextual teacher. He is also contextual teacher. But as the mathematics and
Mr. Bora, because of the difference in fact, the issue also becomes different. That is the difficulty. Because of the difference in the facts, the issue also becomes there. This man was terminated for misconduct.
Yes.
moment it is misconduct, 64 rules are applicable. Okay. 64 rules is regarding an employee. Any employee. So rule 9 has to be followed. Contractual teacher terminated without misconduct, it will 64 rules are not applicable. It will be only governed by Article 311 of the Constitution. 311 is applicable to a person holding a civil post. That is why we are asking you this question.
I will, my termination also is a misconduct, madam. Like
No, there's no misconduct.
Yes, madam.
Where is the misconduct?
Please make kindly say, madam, by putting the stigma, madam. Yes, madam.
Maybe, but not because of misconduct.
Madam, so as per terms and condition of 9, the agreement of your appointment, since your conduct has put black spot in the prestige, reputation, education, and environment of the school. And
No.
consider-
One is
Madam.
taking a disciplinary action for the purpose of misconduct. Other one is your activities are putting a black spot on the prestige reputation. This kind of a man will be little detrimental for the institute.
When I was putting in behind the bar, my love, within 2 days, my love, without notice, without any so-called, my love, they can terminate me, my love.
That's fine.
And thereafter, my love, it came
No,
to-
this is not a misconduct. If this person is retained in this service, it will be detriment to the service.
As per
This
their-
is your case.
my.
Mr. Bora, we have understood your case.
They say that-
There's a difference.
But based on the basis of agreement.
What is a misconduct? This termination is not on misconduct. This termination is on because of the conduct of the person or the nature of the person, the reputation of the institute will go down. Okay. They are teaching. They are apprehensive that if a teacher who is subjected to all criminal proceeding, etc., tomorrow comes and teaches the children, neither the children nor the guardians will be comfortable with it. So because of this image of this person, we do not retain you in service. This is number one. Other one is directly misconduct, that you have done this, I want to hold an inquiry, you'll be terminated. That is covered by the judgment you are referred. This is not a misconduct.
My love, if otherwise, if I will see that. If
That is only, that is
if this order has been passed, I cannot go to any employment because of that by putting this stigma. But I have the money problem.
then we can interfere to that extent if you want.
And on the other hand, thereafter, my lord, I came before the honorable court. Honorable court directed to the director person order. And director also giving the putting the stigma. And thereafter that.
No, do one thing, you remove the stigma.
Yeah.
Take away the stigma, just terminate it. And this stigma will not, or will say this stigma will not be a bar under the law for any further employment.
If your lordship, my lord, is in probationary or any temporary post is concerned, he put given the putting the stigma by the honorable Supreme Court also setting that, my lord, they have to, my lord, proper procedure being followed. As far as 2003, the Supreme Court does. Five, seven.
This is a petitioner failed in his performance of duty. Difference.
But my lord, I am in putting the behind bar in the.
Understand.
I was arrested, and same day I was terminated.
Understand. This
There
is
have to be, my lord, there must be a, my lord.
what will they inquire?
In
Whether a man like you will be good for the children.
But if the
Just
case
a
is
minute.
acquitted from the.
Mr. Maybe acquittal, but your reputation. What will show cause will they give you? And what will you give a reply? That a man who is on this all criminal charges, if he is allowed to teach the children, will it be detrimental to the children? That is the only show cause given to you.
Maybe also sometimes it will FIR may be also false. They can go in behind the bar, then what happens? They will have to.
Don't ask us question what happens. You know, you are a lawyer. It is for you to answer.
So my
Mr.
if the termination.
Mr. Bora,
My lord.
courts are here only to hear submissions, not to give answer to any litigant.
My lord.
Answer, you go to the assembly, you'll get it there. Raise it there, not in a court of law. Court of law will only hear your submission, whether it is legally acceptable, we allow it, legally not acceptable, we'll reject it. We are not here to give any answer to any litigant. What will happen? How do you know what will happen? You find out. Want an adjournment? Adjournment you take. But otherwise, the core issue will have the answer whether these are civil posts or not. Till today, we are getting a number of cases.
Because all are firstly appointed on the basis of the direction by the secretary, madam, and other notification,
No,
and
no.
thereafter hours all are regularized by.
Maybe whether you are go to 311 articles.
Dismissal, removal, or reduction.
Who is a member of a civil service of the union or state, or a civil service of a state, or holds a civil post under the union. So whether is this man holding a civil post?
Initially, my lord, all contextual appointment as a contextual appointment person to the notification issued by director.
That is why.
And thereafter, all are regularized. I annexed.
Mr. Bora, that is why we are asking you, is this man holding a civil post? Find out that, submit on that, instead of raising questions here and there. Questions will not raise you anywhere. And no court is going to, is obliged to give any answer to any litigant, why it is happening to me. You tell us which law is violated, we'll examine. Mr. Bora and Bora petitioner seeks for a further adjournment to examine as to whether the petitioner who was terminated from service was holding a civil post under the state.
Item 37.
Mr. Bora, think it from the point of view. Today you are engaging a daily laborer in your house to clear your concept. Around noon time, you can come to know that this man is a murderer. Will your family be comfortable to retain him for the rest of the day of the work, or do you send him up? You please go. Understood? These are almost situations of that type. But on the other hand, if this person is holding a civil post under the state, you have the protection of Article 311. If you're not holding a post, you don't have the protection of 311. Okay. And these are, mind you, not any charges against you. These are basically because of the reputation of the person. What reputation? The person has gone to jail, the person has been arrested, the person is criminally charged. That's a reputation. Only when there is a charge against you, then there can be an inquiry, what you were saying, give me show cause, I'll reply to the charge. But this is a matter of your reputation. Reputation is already established. It's an admitted position, you are inside the bar. So now what charge sheet will they give you? Will your reputation adversely affect the children of the school? That notice is not required to be given to you.
They think that as per agreement or there is no
It can be done. It's a contract. That's a difficulty.
9 my lord is after.
So find out whether it's a civil post or not. That's the only way out for you, Mr.
After vacation, my lord, ठीक है.
It's, anytime you want. एक वही बोलना है. Yes,
37.
Mr. Karim.
Lordship, in this case, Lordship, the respondents are yet to file the affidavit. On last 2-3 occasions, they shout time, Lordship, for filing affidavit.
Yes.
Your Lordship, extra copy has not been served upon us, Your Lordship. Kindly.
Don't file.
No.
Lordship, this
MS
matter-
Speed asked, Land Council SSA states that the affidavit has not been filed as extra copies had not been provided.
Lordship-
Just again.
Lordship, can it be tagged with on repetition, similar repetition? All along, it was listed together, Lordship.
We'll hear it. Don't worry.
38.
Yes, sir.
Yeah. Lordship, last vacation. That's good. No, my lord.
No, you say you are governed by 2021 Act.
No, my lord.
A order to refer you. Something was recorded there. Please
I've
read the
seen
order.
record. The input order, my lord, was first. Governed by 18 rules.
So produce both the rules
My
first.
lord, that is. Well, let's.
Sixteen three 2022. Which page? 16/3/2022.
Well, that is page 34, Alexa 11.
34. Where is the other
Page-
act? Which
page
page?
24 of this.
24. 24, 24.
Rule 4. What that will
This is for grade 4.
Rule 3 subclause 2B.
3B.
3 2B. Chowkidar.
3-2B. Peon Chowkidar.
Now 4 is the this is the procedure for direct recruitment. Like it was earlier there all along. After coming up this act,
Yes, who appears for the department?
problem is by virtue of the input, I have already crossed the upper age. When I virtue of this
No, we'll
for
take.
last 10 years.
We'll take note of your upper age limit. Yes, Mr. Sharma, what is your submission?
In this matter, we have filed a affidavit, and here
What is your submission on the legal issue? Are you aware what is the issue is? Come to page 34, please. Read the third paragraph from bottom. And where is the earlier order of the court, Mr. Hussain? 11/11/2019, High Court order.
It is page 28.
28.
So here, my lord, government in the legislative department had notification has submitted the to the and promulgated and one act is promulgated, my lord, the Assam Director Recruitment Commissioner for analogous post in Class 3 and Class 4 Act 2021, and second post of the grade 4 of Paka AHS school has already been submitted to the state level recruitment commission for grade 4 post constituted under the state. also, my lord, grade 4 post of the Pata HS school could not be advertised, my lord, as it is submitted to the state level recruitment commission for class 4 post under the Assam Direct Recruitment Commission for analogous post in class 3 and class 4. of the-
Yes, Mr. Sharma.
My lord.
What is your submission?
After some time.
Yes. Your director says that under the Act of 2021, whenever it is advertised, you apply. Hmm. Before that, you read the court order, page 28. Let the post be advertised by the authorities, and the authority will give due credit to the for long service and experience while serving is a grade 4. Efforts at exercise will be carried out within 6 months, 11/11/2019, 6 months. So that means May of 2020. Now you pass an order on 17/3/2022. After 2 years. Now that you go apply as per the 2021 Act, can you do it? Is it a compliance of the court's order? Number one. Number two, which act will be applicable? Secondary Education Rules 2018 will be applicable, or the Act of 2021 will be applicable?
Now grade 3 and grade 4 are coming under this act, my lord, 2021.
This will need a hearing, Mr. Sharma. Have you framed any rules? Under the 2021 Act, has any rules been framed? I think
Because there is
no. Who represents the legislative department, Government of Assam?
after the enactment of this 2021 Act, they called for the vacant position from all departments of the grade 3 and grade 4. And all these posts were transferred to this for filling up the vacancy. And there was a recruitment already initiated.
Then what will happen to the High Court order at page 28?
That we have taken this.
I've read the order because there is something more has been asked. Give due credit to the petitioner for a long service and experience. Follow the rules advertised and exercise be undertaken within 6 months. 6 months means May 2020. Now in this order is passed in March 2022, after 2 years almost. In the meantime, one act comes. So, is it a compliance of the High Court order? This is number one. Number two, we are asking you come to section 10(2). It's with me, yes. It is with me.
Oh, yes. Sorry.
এখন দিয়ে দিব নাকি? We'll come back at 2 o'clock. We'll hear this matter. Tell the court master we can't allow mention now.
Item 8, I missed that item in the morning. Time being, so Lordship may take up on item.
We can't allow mention now.
I'm sorry, ma'am.
There, Mr. Nath, I think it's good we had you. How do you reconcile this 2021 Act vis-a-vis page 28 order of the High Court plus the Secondary Education Provisional School Rules 2018? At 2 o'clock? If you read that 2021 Act, in the preamble, it provides for one condition is that this Act will be applicable where similar eligibility or something is there. I think I have underlined it, please. If there is no similar eligibility, this Act will not be applicable, although it may be a grade 4. Section 3 says that there is a power to exempt certain posts from the purview of the 2021 Act. So that's a positive order has to be there. Unless exempted, Act will be applicable. Last of the sections you read, this has repealed all other existing rules and all. So is the 2018 rules repealed to that extent? And 2018 rules provide for a definite procedure and eligibility. And 2021 Act, just now I read out which section? 10(2), I think. No? 10(2). That the eligibility on all will be as prescribed in the rules. Rules are yet to come.
I'll just check whether the rules have been.
And what will happen if suppose the rules then come, that is at variance with the 2018 Act? Will the preamble come into effect? Preamble only says similar eligibility. Because otherwise what will happen? This will be a combined recruitment for all the departments. The idea is very good that instead of multiple recruitment, which is so expensive, let us hold one recruitment for the whole state. It's a good law. এখনো প্রিন্ট আউট আছে নাকি আরো দিয়ে দিবছেন যদি রুলস কনজারটিভ look into this what kind of orders should I pass now and the High Court says do it within 6 months. They did not do it for almost 3 years and now they say that 2021 rule has come in, now you go and apply under that. It's how to reconcile everything, please submit on that.
But now, because of this repeal clause,
which
because of the repeal clause in Rule 20, Section 21, the 2018 rules in respect of Grade 3 and Grade 4.
No, I understand, but
Difficulty is, my lord, there was a.
no. What about the preamble? Whereas to provide regulatory post in different office necessary, eligibility conditions which are similar.
Eligibility with regard to the qualifications and
Everything, eligibility which are similar. Only then this act will be applicable. If it is not similar, it will not be applicable. We'll hear you. I think you will have. Number one. Number two, court said do it within 6 months.
Yes.
Don't do it. Can the order of the court be frustrated? Don't do it for 2 years. We'll put in one more act and say no, it will go under that one because the terms and condition of the order will now change. Because had it been a recruitment under the 2018 rules as ordered by the court, then there would have been question to give due credit to the petitioner.
Yes.
Now, if he is subjected to a general recruitment, that this due credit will not be given. Yeah, and it cannot be given.
Section 3.
And number one. And number two, his application now will be a general application for all the post advertisement. This may be anywhere in any of the departments. What happened to him of the legal right that is determined against that specific post? Suppose the act is applicable also. Then what happens to that legal right that had been determined?
If this post, as per the proviso of the Section 3 of the 21 Act, has not been included, then there is no difficulty in.
Because now eligibility conditions are similar. So now by virtue of the court's order, this eligibility condition for this post, for this petitioner will be little different.
Section 10(1) of this Act, 22. 10(1), may kindly read 1. It says that the eligibility conditions.
That's what it said, as provided in the respective rules.
In the respective rules. But although the commission will hold the selection process, but the person concerned has to.
No.
He has to apply for a particular department.
Is it so? No. The scheme of 2021 rule does not say. Now everything is merged. By virtue of this act, a prima facie reading shows that all grade 3, grade 4 posts in every department is merged into one, as if it is one service, and there will be one common recruitment.
Then that section makes it rule.
So this is again act is little self inconsistent. Suppose there is a post for education department, another post in the GAD department. Education requires again a particular procedure to be followed. Okay.
qualification maybe little.
Not
different.
qualification.
Computer typing,
No,
computer
not
maybe
qualification.
by somebody.
Not qualification.
10.1 it says the eligibility condition as to minimum educational qualification, essential experience, if any, age limit, reservation for reserved categories applicable for the vacant post shall be as provided for in the respective service.
Huh. So now, very difficult to interpret. Now read the 21.
21. Repeal clause.
Repealed. On one hand, you say it is retained. On one hand, it is said it is repealed.
Yes.
Number one.
But that again also has to be referred to section 3.
Section 3.
Section 3 because when the commission has requisited.
No, no, let us come one by one. We put question to extract an answer from you. Suppose now we read 3 and 21 together. So these eligibility condition, minimum dues to procedure, etc., and as per general provision, these provisions of the respective rules will remain, but the rules itself are repealed. Okay, we accept that.
To the extent of making the direct recruitment, because the
So
clause,
now, come on by one.
clause 3 says.
Now look at schedule 2 to the rules of 2021. It will be at page 54 of that blue book. Criteria for selection grade 4, written test of 50 marks, language, this Bodo language, everything, because mind you, this is a school. So these are criteria are different. Test on general knowledge, 20, qualifying marks, 40 for unreserved. So this part is retained then. Going by Mr. Kaushik's submission of rule 10.1, this part is retained. If this part is retained and there is a general advertisement that we are advertising, say, for 200 posts of grade 4 in various departments, education department is that this department, it will be a general application. No one will be applying for specific education once this comes in. Now for the post of education department, if you give the interpretation of 10.1, page 54 also remains. So in one general advertisement, will it be again?
Nobody will be considered.
And now again, whose application will you consider for education? Because the application will be in general. That's why I say little bit of inconsistency is there.
Look, there is something possibly because of the proper instruction, insufficient instruction, we are not in a position to convey.
And mind you, this rule is especially education department because these people will be working in schools. For school, the medium is very important. Assamese medium school, Bengali medium school, Bodo medium school.
Logic.
But for your GAD or for your personnel department, this may not have a relevance.
Therefore, the exclusion has been given in the 3 provision, section 3 provision.
Application. The act will apply.
Understand? Provided by specific and general, but nothing is there.
We'll have to find that
Because by virtue of this impugned order, what we are dealing with, now it is being said that it will be, he is advised that you advertise when advertised by state level recruitment commission, then you apply.
That indicates that this post is
Included. So 3 proviso is not applicable. What kind of order will you write now? Best way out is that the preamble by a necessary eligibility condition which are similar by holding a common selection test through a commission. Now this common selection test and page 54 of this book, will it be applicable to all the departments? No. But school you'll have to, because school is all medium specific.
Yes, in fact, the act also has given that, so that the department can come up that this is the post for which we require a different kind of eligibility. And therefore, this post we cannot include in the commission.
Possibly something will has to be worked.
It has to be there.
But that will again be contrary to the impugned order.
The order.
Impugned order say you go and apply this. This is regarding inconsistency of 21 and 2018 rules and acts. Then again, what about that due credit for long service? That credit you cannot give it against any one of the unidentified posts in a general selection. It has to be that school specific post where he worked for a long time.
Section 3 has been provided in this act for that purpose.
Maybe.
Section for that purpose. Because there may be certain posts which would require some other eligibility condition other than the
Certain
grade
post.
grade C and grade.
Certain class of post.
Class of.
And certain post also, individual post also. So maybe by virtue of this High Court order, this post
Is to be kept outside.
Ought not to have been included in the.
Possibly.
And I have seen some departments they have kept out their post outside.
Some of the posts.
Yes, outside the purview of this.
This is a very good law because instead of multiple recruitments here and there, make one recruitment, get a government job.
Right.
What do you do? Adjourn.
Lordship may give us some time.
Adjourn on the
because
prayer,
the
Mr. D. Lant and senior
instruction has
advocate
to-
as well as Mr. B. Kaushik. The counsel for the elementary education department to be listed again when we want. But in any view of the matter, it appears the impugned order has to go.
Correct. That is specific interpretation of the officer.
Officer thought one high court order is there. What is?
How-
Oh, one new act has come. Go and apply.
Now there is a rule also.
Go and apply. Don't think anything beyond that.
But in absence of the instruction, it is also difficult to submit before your lordship. Because what procedure he has followed before passing that order, it is also relevant.
Because his orders goes indicates a presumption
That this post is included
included presumption of a proviso to section 3.
Now the act has come. And his reason is that now the act has come.
Act has come.
The post is with the commission, we cannot.
But again, this page 54 will also relevant.
Yes, that has to be looked into. And in fact, the honorable court order is also there in this particular case.
In this particular. See what
Direction is written, that's it.
see how can we can reconcile everything.
Reconcile. Lordship.
Next time lagi Yes, Mr. Kadir.
As per order 21A, the inspector will
Mr. Chisti prays for further 2 weeks time to file affidavit.
Some time will be allowed.
for 21A inspection received.
What is the word next to further?
Some time will be allowed.
No, we'll give you time. Last order was praise for further 2 weeks time. So now what word should we use in today's order? After further, what is there?
No, but
Beyond further.
some time will be allowed.
No, we'll give you time, but what order should I record?
As allowed.
21A melody mentioned.
On the prayer of MSN, Bhukan Land Council for Railway. 2 weeks time beyond the further 2 weeks earlier granted is allowed to the respondents to file the affidavit.
44 orders.
DPR.
Last
Okay.
order, my lord, director has
Comply.
passed an order, my lord.
You got the order.
My lord, actually, this is not a complex order, my lord. You will kindly see the.
No, it may not be complete, but after the order, will there be any willful and deliberate violation?
My lord, rational of the court was to, my lord, consider my post as a language teacher, my lord.
Where is the order violated?
My lord, at page, my lord, 9, my lord. Of
Page 9.
Your lordship, my lord. Biscuit is, my lord,
And what order has been passed?
My lord, enrollment is not sufficient. So SL.
What school is this? LP school?
ME school.
ME school.
MEM. Upper primary.
What is the difference between a Hindi teacher and a language teacher? No, what is the difference between a Hindi teacher and a language teacher?
Language teacher include MIL.
No, I know. I'm not asking you the difference. Language is more broad-based. It will include all languages. Hindi is only one language. But is Hindi teacher also not a language teacher? Or Hindi teacher is different?
Hindi teacher, Hindi subject contains to Parangon and
Mr. Sharma, your answer is something different. If you read Rule 13 of the rules, 2017 Act, That page 111 of that book. In case of venture upper primary school, there shall be minimum 3 teachers or tutors and at least 1 teacher for science, social studies, and languages. Word is languages, mind you, not language also. Will a Hindi teacher be also included as a language teacher? Where is Mr. Chisti?
Yes, ma'am.
Please ask him. Yes. Chisti or Mr. Kaushik? Mr. Chisti, first you read page 11 of this petition. Do you have it? Para 6.
It is, yes, yes.
This is a condemnation. Read para 6 of that order.
In view of the above, we dispose of this writ petition directing the Director of Elementary Education Assam to consider the claim of the
Petitioner as a language teacher. Okay.
As a language teacher, yes.
And pass a reason. In doing so, examine the records as to when the petitioner was appointed.
And for what subject? And
What subject? And if the record really is a language teacher
Yes, no. The school concerned of
from the year 1993, if otherwise eligible. Otherwise eligible means anything other than this being a language and all.
Yes.
Directed to pass a reason order thereon. Means it's almost a mandamus to provincialize. Only thing will verify whether he is a language teacher or he is not a language teacher. Now read this order that is placed before us. Come to that first page, findings.
the petitioner suddenly appointed.
There's recommended 5 teachers. Look at serial number 3, Sokina Khatun.
Yes, Asian teacher.
As a recommended as language teacher. Appointment 1999.
Yes.
Shahjahan Ali petitioner.
Hindi teacher.
Hindi teacher appointed 1994. Appointed prior to Sokina.
Yes.
Recommended as additional teacher.
Yes.
Then ultimately the director says that considering the enrollment in the school is not entitled to an additional teacher, so you reject. But we are asking you, is Hindi teacher also not a language teacher?
Otherwise, the language teacher, but the requirement.
And if you see the language of the act, in case of venture, at least 1 teacher each for science and mathematics, social studies, and languages.
Yes.
It's not just a singular, it's in plural.
Yes.
If Hindi is a language and Shahjahan date of joining is 94, why was Sokina provincialized? Please. And order of the court is to find out whether he is a language teacher or not.
Yes.
Your finding is, if Hindi is not a language teacher, we don't know. But if Hindi is also a language teacher, he is a language teacher.
In this last week, I can take it up on Friday. I will come back with it.
Is there any decision whether Hindi teacher is a language teacher or not? Or Hindi teacher is something different?
Decision, I have no idea. I have to take.
Claiming compliance of the order which is alleged to have been violated, an order dated 26/8/2022 of the Director Elementary Education Assam has been produced before the court. The order reveals that Sokina Khatun was recommended to be provincialized as language teacher, having the date of joining as 25/11/1999, whereas Shahjahan Ali was recommended to be provincialized as additional teacher and he is also shown to be the Hindi teacher having the date of joining as 1/1/1994. Going by the date of joining, Shahjahan Ali appears to be senior to Sokina Khatun. But by virtue of being a Hindi teacher, a question that would arise is whether a Hindi teacher is also a languages teacher, or a Hindi teacher is considered under the provincialization rules to be a teacher other than a language teacher. Mr. SMT Chisti, Learned Counsel for the Elementary Education, prays for an adjournment to examination same and confer the matter with the director. Okay?
Yes.
Yes, you wanted to say something? You wanted to say something?
My lord, as per my lord, section 3(1)(11), my lord, there must be at least 3 teachers, my lord, in upper primary school. But in case of this school, my lord, only 2 teachers has been provincialized. Language teacher is not provincialized, my lord. It is lying vacant because the person who was recommended for provincialization, she was not eligible, my lord. That's why her service has
Okay, it is not provincialized.
Yes,
From where do you say?
my lord, it is from this order.
Which line?
My lord, page 3, my lord, this order. Hanif Ali, head teacher, and Shahida Islam, teacher studies. These 2 teachers have been provincialized.
And there is no provision to provincialize a headmaster.
The headmaster, there is no provision.
He has to be one of the teachers,
One of the-
3 category teachers. No one can be provincialized as a headmaster. So don't you think this order violates our order of the court? When the order of the court is very specific, you'll only examine whether this man is a language teacher or not, and whether he was serving from the year 1993. If he has provincialized. But director has gone in a totally different direction. Provincial is one head teacher. Then district committee for some reason designates this man to be an additional teacher. I don't know why. Then you say additional teacher is not entitled, reject.
Additional teacher and the only subject to the enrollment of the student.
Understand, but he is not an additional teacher. Why will you designate him as an additional teacher?
Because he was recommended by the district school committee as a rate.
So, district committee is not sacrosanct. That you tell somebody to be additional, he becomes additional. Who is additional? Mr. Chisti?
Yes.
Who can be additional? In general, forget about your teachers. Who can be additional?
Find out who is exactly additional. Yes.
No. Under the concept, who can be additional?
When the enrollment is above 80 lakh.
Forget about your rules and teachers and the concept additional. Who can be an additional?
When already there is an Hindi teacher.
When not Hindi teacher, when there is already existing somebody, the man coming next is additional. Here, this man came in 94. Additional came in 94. And the regular came in 99. How can the additional come before the regular? Look into it. Come back. List on sales.
41.
A copy of the order of 26/8/20 kept on record. It's 41.
May I please, Your Lordship?
Matter which relates to
Selection of. All right, so the matter relates to selection of president, vice president. That is the issue, Lordship. And whether is a mandatory, the person.
Selection of
President, vice president of the school, Lordship, secondary school. As per notification, Lordship.
So today what is to be done? Adjourn on the prayer of Mr. Borobhia. First establish as to what right Devanand Singh and others have to claim president.
Lordship, page 25.
No, don't tell us what you said the other day. We have put one question to you.
Yes.
Please answer the
My
question.
right goes from that notification. That's why, Lordship.
Which notification?
Page 25, Lordship. Notification dated 27 June 2016. Second paragraph, may I read, Lordship? The School Management and Development Committee have a major role in improvement of quality in secondary school, and many responsibilities have been delegated to the SMTC, like selection, principal, headmaster, teachers, financial management, etc. In addition, the
Mr. Borobhia,
that
please speed up a little because a lot of people are waiting behind you.
then
We can't allow you to read one page and consume 10 minutes for that.
No, I am
Tell us what you want to submit.
Lordship, from the language of this notification, Lordship, the selection is mandatory. Yes, Lordship. Yes.
Your case is that some local people had recommended Devananda Singh, but the authorities had appointed another person to be the president. We are asking you what legal right Devananda Singh has.
Yes, from my ligature of.
So where is the provision that whosoever the public chooses has to be that man? Where is that provision?
That's why I am reading this notification.
Don't read, tell
Not
us.
whole notification, particular paragraph.
Read from which line your right flows.
Lordship, my rights.
See, if
flows
everybody,
from that notification.
Mr. Borobhia, if tomorrow everybody starts taking this approach that to establish my right, I read everything.
I am not.
We have no difficulty. We'll take up only one case one day. So point out which relevant sentence so that we understand.
Second, in the paragraph 25, third paragraph, the government notification, byte number so dated 6th of August, does not lay down any criteria for selection of the president, vice president of the SMDC into the uniform qualifications, etc. Many responsibilities have been delegated to SMDCs like selection of principal, headmaster, teachers, etc. In addition to powers conferred, the SMDC has narrated below for which certain qualification of the president, vice president of the SMDC. Then let's come to page 28. Selection process. The inspector of schools.
So now tell us,
Lordship.
selection process is inspector after consultation with the principal, headmaster and local people.
Lordship.
How can this provision be interpreted to mean that whosoever is recommended by the local people, mandatorily only that man has to be appointed?
I am coming to Lordship.
Please come. This coming
Then
business, we
next line,
we
Lordship.
don't have so much of time.
Lordship. Next line. Who has to select and who has to approve an appointment? Lordship, with the recommendations of the deputy commissioner within a period of 30 days, after considering the names of directors, secondary education, Assam will provide the list to the government, with this government for selecting single name after comparing date of both the candidates, and then government will approve. So
No,
my
Mr. Parvaya,
submission
we
is-
understand.
My understanding is that after submission of the names before the inspector is good, inspector should forward the names to the director, and director would
Mr.
forward
Borvaya,
the
difficulty is you are saying everything else other than answering the question. Your saying here and there is not leading to an answer. We are very specific. And whatever procedure you are trying to repeat again and again, we have read it.
Yes, I know.
Inspector in consultation with principal, headmaster, and local people. Word is consultation. Who will recommend? Inspector will recommend. In view of this provision, if the local people says that X should be the president, to what extent it is mandatorily binding on the inspector that he'll have to recommend only that man and nobody else? If you have understood the question, answer. If you have not understood, don't answer.
There are two names directed to forwarded to the director. Director will select one person and government will approve. Then second notification lawsuit, page 32.
Don't tell us about the facts. We are aware. And these are regulation matters which come up almost every day. Every day we read these notifications.
Next notification stage lawsuit, page 32. Page 32 lawsuit. Some partial modification been downloaded. In partial modification of the guidelines for constitution of school management and development committee issued by notification number so-and-so dated 24/6/16 and the letter dated so-and-so 5/17, the deputy commissioner is hereby empowered to select the president and vice president of the school management development committee of an education institution of the concerned district with the approval of the guardian. Earlier, my understanding is that lawsuit as per notification, director will select. Here the deputy commissioner with consultation of the guardian will approve. From that on the basis of notification, partial modification lawsuit, the earlier modification says only that director will select one person, the government will approve. And second notification find that director powers is withdrawn, deputy commissioner lawsuit. And the deputy commissioner will select. In the imprenodal lawsuit, here is the APR, inspector of school has recommended, selected with the consultant. Imprenodal is
Which page?
Page 47.
Page 47.
So what legal right of the petitioner had been violated?
My right was from that initial notification. Yeah, in the imprenodal stage lawsuit, from that on the basis of notification in 2016, this person has been selected. But their names never been forwarded. And on this regarding legal right lawsuit, I relied upon some decisions of the honorable effector. May I placing first one I placed in 1974 to SCC
Where is that 27/10/2021? You have it with you, Mr.
Page 32. Page 32.
32.
Is the partial modification of the earlier?
Well, this is given only the deputy commissioner.
Yes. Earlier, the power was given to the government. That has been changed. Deputy commissioner has been given the power to select and appoint with the approval of the guardian minister.
So what is wrong with this order? So they say the guardian minister had approved it.
Approved. And this page 47.
And the inspector is only communicating the order.
this
He is
is
not
just a communication.
appointing anyone.
Yes. Page 47 is a communication
It's a communication.
as per the approval
Yes,
of.
you argue, yes. What decision want to say? Which decision you want to rely on?
1974 lawsuit to SCC. 1974 to SCC. Page 387. Kanti Kumar R. Kanji versus the.
No, you don't have to read everything, Mr. Borgia.
I am sorry. Paragraph
You are consuming time of others.
Paragraph
Some learned
17.
counsel will have to go back disappointed at the end of the day. Matter is not called. You are only doing, and you won't gain
Paragraph
anything by that.
17 lawsuits.
Paragraph 17.
Paragraph 17. The right to claim that that an introduction of a cause of action by amendment is barred by limitation is founded on immunity from a liability. A right is an aberrament of entitlement.
Yes, we read it. Yes, next one.
Yeah, next one is lawsuits. 1984 3 SCC.
1993 SCC.
1984 lawsuits.
84.
3 SCC.
3 SCC.
161.
161. Yes.
Paragraph 11, 12,
11.
11, 12.
What does it provide?
Details very long. Paragraph 11 lawsuits in page at 185 lawsuit in the middle after 8 line 1.
Page 100, 184.
185.
85.
Paragraph start from 185. Middle part lawsuit 185. After 14 lawsuit will find it was on the basis of this impression. It was on the basis of this impression fostered by long association with the Anglo-Saxon system of administration of justice that for a number of years this court had taken the view that it is only a person whose fundamental right is violated who can approach the Supreme Court for relief under Article 2.
How is this Bondhua Mukti Morcha relevant in your case?
Then I
Bondhua Mukti Morcha, some people were subject to slavery. There the Supreme Court espoused the cause of Article 21 of the Constitution. How is it relevant to your case?
26 also here is the clarified lawsuit base.
Okay, anything more?
15, then paragraph 15 lawsuit.
Enough. I think we have heard Mr. We are vacating the interim order.
They have not filed any vacation petition.
May not have. We are also
The school is without.
till the next returnable date. So we have to consider whether to continue or not on every day.
I leave it to lawsuit,
But
yes,
we repeatedly gave you opportunity.
Discussion on lawsuit. I leave it to lawsuit.
If you could have pointed out some good legal right, maybe we would have continued it. But nothing is there. We'll hear you at the end. And the man who is appointed is quite a respectable person. It will be good for the school.
In comparison to the.
It will be good for
they
the
are also
school.
qualified of that area.
Maybe.
Persons chooses. I know my friend.
So
respectable. Yeah, I
no,
know.
that is not the
Here is the case between
that is not
petitioner
the
and
that is not the factor. Factor is where is it that the person nominated by the local people will have precedence over everything, and it will only he be the. That answer we are not getting anywhere. Let us waste no time. We've given you almost.
All
the long enough a time because others will suffer. Heard Mr. F.U. Borbhuiya, learned counsel for the petitioner. Also heard Mr. B. Kaushik, learned counsel for the respondents in the secondary education department. The petitioner assails the 47 actually.
47 is the
Assails the communication dated 27/2022 from the Inspector of Schools, Kamrup Metro, to the principal stroke headmistress cum member secretary of the school managing committee of LOG Hindi High School. The communication is extracted as below. A reading of the communication makes it discernible that the communication from the inspector of school communicates a decision that had been taken to appoint the two persons named therein as the president and vice president of the LOG Hindi High School, and that the decision for the appointment has the approval of the guardian minister. The communication is assailed on the ground that, as per the notification dated 27/10/2021, the president and vice president of a school, of the SMDC of a school, is to be selected by the deputy commissioner with approval of the guardian minister. And as the notification gives the authority to the deputy commissioner to select and the guardian minister to approve, therefore, the inspector of schools could not have issued the order of appointment. We have noticed that the impugned communication dated 27/2022 is not an order of appointment by the inspector, but it is merely a communication of the decision that had been taken with the approval of the guardian minister, which appears to be consistent with the requirement of the notification dated 27/10/2021. It is further contended by Mr. F.U. Borbhuiya, learned counsel for the petitioner, that as per the notification dated 27/6/2016, the selection procedure of the president and vice president of the SMDC is that the inspector of school, after consultation with the principal stroke headmaster and local people, will forward two names to the director, and the director will provide the list to the government with its comments. And thereafter, the government will approve the recommended names. It is the claim of the petitioner that the writ petitioner Devananda Singh had been recommended by the local people of the area, and therefore the authorities could not have appointed another person who was not named by the local authorities. Yes, what do you want to say?
Not only the one, the four persons named
Forget about
forwarded
it.
as president. Four persons.
Please.
And
Devananda Singh, along with others, put it with you. So that form. In view of such submission, by our earlier order dated 4/10/2023, we required the petitioner to make their submissions as to what legal right the petitioner Devananda Singh has to claim to be the president, merely because the local people may have recommended his name. And secondly, also as to what public interest would be served if only the writ petitioner Devananda Singh is appointed as the president and not the other person who had been approved for the appointment. Today, when the matter is heard on the aforesaid issue being framed by the order dated 4/10/2023, Mr. F.U. Borbuya, Land Counsel for the petitioner, takes the court through the provisions of the notifications dated 27/6/2016 as well as 27/10/2021 and submits that the procedure provided therein indicates that it is only the local people whose selection would prevail. Having gone through the provisions of the two notifications, such provision is not discernible, although it is the submission of the learned counsel for the petitioner. The petitioner relies upon certain pronouncements of the Honorable Supreme Court rendered in Bondhua Mukti Morcha versus Union of India, reported in 1984, 3 SCC 161. And Shanti Kumar R. Kanji versus Home Insurance Company of New York, reported in 1974, 2 SCC 387. To substantiate as to what is a legal right. Although the law pertaining to as to what is a legal right had been placed before the court, but the requirement of the order dated 4/10/2023 that a person that the person who is recommended by the local people to be the president of SMDC alone has to be recommended is not answered. In view of the above, no prima facie case being made out, no prima facie case of the petitioner is discernible, having been made out is discernible. Nothing has been indicated that the approval granted by the Guardian Minister as per the notification, as per the provisions of the notification dated demand, preceded by any violation of any of the procedural requirements. In view of the above, we are not inclined to continue with the interim order dated 11/8/2022 accordingly. Writ petitioner to be listed for hearing. Yes, enjoyed interim order for more than 1 year. They'll let him do. We also take note that because of the interim order, the school is functioning without a president of the SMDC, which is again detrimental to the school. And from such point of view, the balance of convenience and irreparable loss would be against the petitioner and in favor of the respondents. Sorry.
Two other more judgments already.
You want that also? But these are on some other points. Not doesn't answer the question.
42.
Yes.
There is a contempt petition.
The notice served. Notice served.
No, Lordship. As per the office note. there is
David
no
service report as per
received.
office note dated.
5/10, Lordship.
Hmm.
5/10.
5/5/10/2023. List again.
43.
Contempt, madam.
May I pray for some time?
The Kochi takes notice of the requirement to provide information as to what further order the director may have passed pursuant to the order dated.
We will take up next week, my lord. I can produce the speaking order. I have just talked to the
Person
director.
going to be retired in December, my lord.
Otherwise, my lord, the director, your lordship, in this order, direction was given to proceed with the regular promotion under the 2018 rule, as it has to be done as per the gradation list, district gradation list. Director has already called for from all the district, the gradation list from the district, and the process of promotion is undertaken. Or
Including the petitioner.
it might include the petitioner because the gradation list, whether the petitioner.
No,
name is there
what
or
is the order of the court? Direction to look into the grievance or to take necessary steps. Disposed of the representation.
Yes.
Have you disposed of?
That will be done, my lord.
Do it. See, if the man is retiring, suppose your disposal order is against the man, he'll at least have one opportunity to come to the court. But if you don't do it, how can he come?
Next week, my lord.
If you give him the relief, it is well and good. The man will enjoy it.
I've just talked to the director, my lord, will pass.
The order in respect of the representation of the petitioner dated 15/5/2023 be placed on record on the next returnable date based on since.
45.
45.
The morning, my lord, I have sought for adjournment with item number 18, my lord. Since there is an interim order in item number 45, my lord has wanted to hear.
What is the interim order? It's
Interim
continued.
order, my lord, 23/8/2023.
I don't know, the interim to continue to the next returnable date.
My lord, kindly check this matter with item number 18. My lord, petitioner and respondent are both same, my lord. In this case, my lord, issue was different, my lord.
No. Can we pass one common judgment in the two petitions?
No, my lord, that.
Then we
that might-
will not take,
might-
we'll
might-
decide separately.
Also, interim order may be considered.
Obligation.
Item 46 for admission.
My lord, everything is ready. Tomorrow I will file this application.
On the prayer of MSN Fukan and Council of Element,
Tomorrow I will.
2 further weeks granted to file the affidavit.
47 and 48 for orders.
My lord, belong to.
That day, what happened?
It is more or less sorted out. We are going to hold the election within 2 weeks. So your lordship
So we
will-
adjourned it for 2 weeks?
For 2 weeks only.
It's stated by Mr. S. Dottal and Senior Council that the elections are likely to be held within 2 weeks. In view of such statement, list after 2 weeks.
Much okay.
49 for hearing.
May I please? The proposal is ready, we'll consider it in the next governing.
Sorry?
Proposal is ready, lordship, we'll consider it in the next governing body meeting.
Acha, for promotion proposal.
Oh.
Mr. B.P. Boral and counsel for the Pup Kamrup College makes a statement that a proposal for considering promotion of petitioner is
Is ready.
Ready.
We'll consider it in the next governing.
would be considered in the next meeting of the governing body. When will it be held?
Just.
To be held on or before?
On or before puja.
Which puja?
This puja, but now golden.
Within 15 days.
List of 4 weeks.
4 weeks. No, list after 4 weeks. You hold your meeting and list after 4 weeks.
Production list for motion item 1.
This is the application file for the regularization of the petition in the service. She has been continuing the service for long 30 years.
No. So now what will happen? What was the urgency today?
Urgency in the sense, my lord, I have the instruction that they are going to remove me from the post of principal in charge and bringing someone from the instrumental department who is from, my lord, as the lordship understand, is not from the education department. The instrument who is his work is to.
I heard this. Maintain the status quo. We'll hear you next week. Not next week. I think next week will be too near the vacation. We'll give you a date immediately on the reopening. In the meantime, you file your reply. We'll pass a final order, whichever way it is possible. Till then, maintain the status quo.
Hello, current status of the petition.
As on today.
Yes.
Mr. S. Total and City Council, we also heard Mr. M.J. Chairman, Land Center Council for the respondent, Brahmaputra Valley Fertilizer Corporation Limited. Notice returnable on fixed date.
10th November.
Extra copies within 3 days. Till the next returnable date, status quo as regards the service of the petitioner as on today be maintained. Upon the filing of the affidavit, an endeavor shall be made to give a final consideration.
He's no longer the principal.
Sorry.
He's no longer acting as the principal.
No, as on today, whatever it is.
Yes, as on.
For RDB. Yeah.
Timing item 5. Oh, you missed out a date.
It is 13/11.
No, now I don't know. I'll have to hear you again. I heard that. It was not placed before.
It was placed before, my lord, the petitioner has initially filed before the DLC in the required time. It was rejected on the grounds of no qualification. Thereafter, petitioner again applied at page 47, my lord.
Rajibar here to likha ase niki? Tomar tate ase niki? Nane hetu porile mor monot poribo. Nohole aru hunibo lagibo. What are the pages I looked into in the morning?
My lord, at page 47.
47.
47 of the affidavit filed by the department.
Petitionary Gond.
Sylvester Gond at serial number 18, my lord.
Late submission of 2 years.
Yes.
Date of application 13/11/17.
17 is the second.
Second, what is the first one?
First application was placed, my lord, immediately, which was rejected on 2012. As per
Which page?
As per the department's affidavit, my lord, at page 37, my lord.
It was rejected on what ground?
It was rejected on no qualification, on the ground of no vacancy and no qualification, as the application was made in grade 3, my lord. He was not accommodated in any other department, and my lord, no communication was made. We again, when it came to
Third MSG Verbal and Conservation. The petitioner the father of the petitioner, Siveswar Gogoi, who was the headmaster of Ghatwating LP School, died in harness on 11/11/2010. And on his death, the petitioner submitted an application for compassionate appointment on which date, Madam Borwa?
my lord, here the date is not, my lord, immediately we have
Immediately thereafter, the said application
was rejected.
was rejected by the DLC in the year 2012.
9/7/2012.
9/7/2012, that the petitioner was not qualified and nor any vacancies available. It is taken note that the application of the petitioner was considered against the post of assistant teacher in a school. The law of compassionate appointment requires the application to be considered against any available vacant post for which the person may be qualified, and not that the post that the consideration has to commensurate with the post the deceased had earlier held. From such point of view, there was also a requirement under the law to consider the application against any other vacant post in any department for which the petitioner may have been qualified. But as it was not done, the petitioner made another application dated 13/11/2017, which was considered by the DLC of Jorhat district in its meeting of 5/4/2018, and the application was rejected by referring to the OM dated 1/6/2015 that as the application was submitted beyond a period of it was submitted on the ground that on the ground of late submission and that duration of 2 years have exceeded. The late submission is explained on the as per the facts noted above that the earlier application which was made on time was not given its due consideration and the later application was only a reminder as regards the kind of consideration the earlier application deserved to be given. From such point of view, the letter of application 13/11/2017 cannot be constituted to be an application which was submitted late. As regards the other ground that 2 years have passed by, there is a requirement of law that the earlier rejection must be because of one of vacancy and thereupon the application is pending for more than 2 years. As we have already noted above, the earlier application of petitioner itself was not given its due consideration as the petitioner was not considered against a vacant post for which he is duly qualified. Rather, it was rejected on a presumption that the claim of the petitioner is required to be considered against the post of a teacher. From such point of view, the rejection by the DLC in so-and-so set aside, remanded back to the DLC of so-and-so for a fresh consideration as per law to be placed before the next available DLC. Thank you.
Item 11.
Yes.
11 record receipt matter.
Petition of case was rejected by the DLC on the ground that he was minor.
Which page?
Page 22, Lordship.
22. Yes, sir. Why did he pass the order of 8-9? Complete reasoning of all the candidates. Normally, I pass this one when you have not done the inter-se comparison in a proper manner. But here is a case. He was rejected. He was 13 years, 7 months at the time of submission. But at the time of consideration, he was a major. Santosh, para 35. Heard Mr. N.H. Borbhuya, then counsel for the petitioner, also heard Mr. P. Saikya for the Deputy Commissioner Hailakandi and Mr. B. Kaushik for the respondents in the Elementary Education Department, Government of Assam. The father of the petitioner, Ranjan Kumar Suklaboido, who was an assistant teacher in the 182 number Choto Jamira LP school in the Hailakandi district, died in harness on 14/1/2013, and on his death, the petitioner submitted an application for compassionate appointment. The said application was considered by the DLC of Hailakandi district in its meeting of 5/10/2021 and rejected on the ground that at the time of submission, the petitioner was 13 years, 7 months, 13 days. Had the application been considered at the relevant time when it was made, perhaps the reason of rejection may have been a valid reason. But it appears that the application was considered on 5/10/2021, and as on the said date, the petitioner was not a minor, as he had attained majority in the meantime. Law in this respect is settled by the Supreme Court in para 35 of its judgment rendered in NC Santosh also reported so and so. wherein it provided that the norms prevailing on the date of consideration would be the relevant factor, and admittedly on the date of consideration, the petitioner was not a minor. From such point of view, the reasoning of the DLC in rejecting the petitioner is unacceptable in law. Matter remanded back to the DSL for consideration. Please, in the next available meeting.
Item 13.
It's,
My lord.
what was this matter?
That my lord,
KSC, suspension
suspension
by the somebody of
by the authority of Karbi Anglong, which is what my lord authorized to.
page number.
My lord, the impugn order is page my lord 26 and extra 2.
26.
Type copy that for the positive next 28.
Mr. Trutia, Additional Director Education, Karbi Anglong Autonomous Council. He is somebody from the council.
My lord, he's the, my lord, appointment by the government, my lord.
No, maybe government, but he is a
Under the
under the
administrative
council.
control- Under the administrative control of council. my lord.
Can he place this man under suspension?
My lord, as part of my lord resolution adopted by the Assam Legislative Assembly, the executive power of the my lord education department, including the college education generally is transferred subject. Accordingly, the notification, my lord, today, my lord, the Hansaria's book is there, my lord. It is in a Hansaria's book.
Take it. College education is also handed over.
College education general, my lord. And today, my lord, there is a matter fixed by the division bench tomorrow, my lord, regarding suspension of the principal by the college, by the principal, by the Karbi Anglong Autonomous Council to the, my lord, by the council. That matter tomorrow, that matter will be taken by.
How
division
is it
bench.
gone to division bench
My lord, there
directly?
is a judgment of the single bench. There is a appeal was filed by the state of Assam.
Okay, against the judgment of the
The
single bench in
and
appeal.
is that is fixed tomorrow, my lord.
Hmm.
And in that case, my lord, we have filed the affidavit. The council has the power of the college administration is the transfer subject, and the honorable division bench tomorrow, my lord, fix the matter.
No, no, let us take a look
My
at
lord,
that
my lord, my lord.
notification.
I'm giving it, my lord. 1996.
Agreement as this is.
Got it?
Yes, ma'am.
The law making power is the 6th paragraph 3, my lord, regarding the primary and
Just a minute. But this notification also gives education, primary education up to the level of high secondary education.
My lord, that is the, my lord.
But this is a college.
My lord, it is the lawmaking power given under the, my lord, 6th schedule, primary and secondary education. So we have the power to make law on that subject. And the college education general, my lord, that subject was transferred, my lord, subsequently, my lord.
By which notification?
That notification, my lord, in the next page.
Next page.
There are subjects are there, the college education general.
College education. Where is it? College education general, including library, 23. Now, this is under para 6 rule 2. But the 6.2 does not include the education.
My lord, constitution.
Sorry.
My lord, in the constitution. 6th schedule.
Uh,
My lord, 6th schedule.
6th schedule,
Paragraph 3.
para 6.2.
Paragraph 3.
Mr.
Oh.
This notification you referred,
My lord.
this is in exercise of power under subparagraph 2, paragraph 6. Okay.
My lord.
You have included college education.
My lord.
But 6.2 says governor with the consent of any district entrust to that council officer in relation to agriculture, animal husbandry, community projects, cooperative societies, social welfare, village planning, or any other matter to which the executive power of the state extends. This is one. Education is not included. So, para 6.2 notification cannot cover college education, even if it is without jurisdiction. Number one. Number two, if you come to powers of the district council, this is para 3.
Para 3.
Para 3.
And para 3 capital A.
I know. Para 3 A to J does not include education.
No, primary and secondary education is included.
But 3A says primary and secondary. So moment it is primary and secondary, up to primary and secondary, you can make your rules.
Make law.
And you make law and also exercise power on that subject. But beyond that, you cannot.
My lord.
So possibly,
My lord. Yes, sir.
college authorities, the council does not have the power to suspend.
That point is, my lord, pending, my lord. Tomorrow that point.
Not pending, it's, we are interpreting the constitution.
My lord, lordship, my lord, today, my lord, that I have not the brief and all the books, my lord. If it takes the day after tomorrow, my lord.
Okay, that is okay.
Day
That
after
we can
tomorrow,
hear
my
you.
lord.
So that tomorrow's days is
If
is a division bench, you will see what
I'm
you
not
say.
saying, my lord, on that case, that Dr. that Deepu Government College principal case, my lord.
But that is
that case. In that case is also there, my lord, why we have suspended him, my lord. Deepu Government College principal, my lord. And that case, my lord, yes, today, my lord, that case, my lord, went to the division bench, my lord. In that case, we have suspended him. So the division bench today asks that we have taken the plea that a college education general is the transferred subject. So the division bench today's view that the government does not have the power. So Advocate General was asked to submit tomorrow on that aspect, whether we have power or the council have the power. College education general, it is a transferred subject. So my lord.
No, this is not a transferred subject.
By virtue of, my lord, the notification, my lord, adopt and the resolution adopted.
No. Under para 3 capital A 3, it is not a transferred subject.
No,
under 3A, it is not a transferred subject.
Inherent subject.
And para 6.2 gives the power to the governor to bring in certain subjects, but education is excluded.
Yes, but that is the
So,
difference between
para 6.2 notification,
Council, that is the difference.
We'll do one thing.
Have the power, we don't have power.
Mr.
My lord,
We'll
I
do one
understand,
thing.
lordship, already a lordship earlier. Also
No,
lordship dealt with the
because Mr. Sorodia will be prejudiced.
My lord.
Because what the
provincial
division bench will say, we don't know. He will not have an opportunity to answer. So what we do, we make our observations in today's orders and we fix it up for tomorrow. So that what he submits is also relevant. And if necessary, you can go and appear in the division bench. Say that I also want a hearing because my case is pending and this is the order passed today. This is the issue frame. Otherwise, you'll be prejudiced. Suppose it goes against you, will be bound by the division bench. But he has raised a issue that requires.
But today, my lord, that our names are not shown in the code, so I did not bring
No, doesn't matter. No, we'll only frame the question and fix it for day after tomorrow.
Day after tomorrow.
But we'll frame the question.
My lord,
It's not a simple adjournment. Third, Mr. M. Sarania, learned counsel for the petitioner, also heard Mr. D. Upamanu, the counsel for the Higher Education Department, and Mr. G. Chotia, learned the counsel for the respondents in the KAAC. An order dated 3/7/2023 of the Additional Director of Education KAC is assailed in this writ petition, by which the writ petitioner Dr. Harvey Inti Katharpi, Assistant Professor in the Department of History, Rukasen College, Bokolia, is placed under suspension pending Royal of Departmental Proceeding. The order of suspension dated 3/7/2023 is assailed on the ground of jurisdiction that the Additional Director of Education KAC, being an authority under the KAC and not being an authority under the Government of Assam India Higher Education Department, is, please don't disturb. Don't disturb. It does not have the jurisdiction to pass an order of suspension in respect of assistant professor in a college, in as much as college education is not a transferred subject to the KAC under the 6th schedule to the Constitution of India. Yes, what you wanted to say?
He's the government officer, but administrative control of council.
No, he's a authority at present, authority under the
He's the government officer appointed by the government.
Doesn't matter. Once he is posted in KAC, he is an authority under the KAC. He does not retain any further power to act on behalf of the government of Assam. Repeatedly, we are having BTC cases. Any director of education, although appointed by the government of Assam, is represented by BTC, not by the government of Assam. Government of Assam straight away says he is not our man.
We are always saying that he is under administrative control.
Totally. So today, suppose for some reason, I'm asked to go and sit in Meghalaya High Court. Will I be the judge of the Guwahati High Court? For at least that period, I'll be there.
Regarding my lord, that notification specifically provides that we have only the power of the intra-council and transfer posting, and in respect of the departmental proceeding, we have the.
At present, this man is functioning as an authority of the council. He is not functioning as an authority of the government of Assam. কি বলো? Mr. J. Chotia, learned counsel for the KAC, refers to the notification number HAD full stop 57/95/268-269 dated 25/9/1996 of the Governor of Assam, made under paragraph 6(2) of the 6th schedule to the government of to the Constitution of India, by which at entry 23, college education in general had also been included as a transferred subject to the KAC. Stop. Mr. J. Chotiala, Council of KSC also raises the contention that the additional director of education KSC is otherwise an officer of the government of Assam in the higher education department, and therefore he is to be construed to be an authority under the higher education department of the government of Assam. The said submission does not find acceptance inasmuch as the additional director may be otherwise a member of the higher education service of the government of Assam. But upon being placed at the service of the KAC for the relevant period for which he continues to remain there, he has to be the additional director of education would have to be understood to be an authority under the KAC and not to be an authority under the government of Assam. As regards the notification dated 25/9/1996 of the governor of Assam under paragraph 6(2) of the 6th schedule, providing college education in general at entry 23 to be also a transferred subject, we take note that the concept of transferred subject is provided under para 3 of the 6th schedule, wherein certain subjects have been provided under clauses A to J, and the subjects provided therein are constitutionally to be understood to be the transferred subjects. Paragraph 3A, which was subsequently brought in by the 6th schedule to the Constitution Amendment Act 1995, provides for certain additional powers of the autonomous councils, including the KAC, wherein in clause D thereof provides for primary and secondary education. A conjoint reading of para 3 and para 3A makes it discernible that as per subclause D of para 3A, primary and secondary education is also a transferred subject to the KAC. But conspicuously, college education or higher education does not find place in the transfer subjects of para 3A. We also take note that a notification dated 25/9/1996 had been issued by the Governor of Assam in exercise of the powers under para 6(2) of the 6th schedule to the Constitution, which inter alia provides that the governor may, with the consent of any district council, entrust either conditionally or unconditionally to that council or to its officers functions in relation to agriculture, animal husbandry, community projects, cooperative societies, social welfare, village planning, or any other matter to which the executive power of the state extends.
So the college education was entrusted. And the first part is the, my lord, inherent subject, and this is the transferred subject. And paragraph 3 is the inherent subject. We have the power to make law. In those subjects, extended subject, we don't have the power to make law. That is the difference.
A reading of clause para 6(2) would make it discernible that The Governor of Assam may, with the consent of any district council, entrust either conditionally or unconditionally to that council or to its officers functions in relation to the departments stated therein, namely agriculture, animal husbandry, community projects, cooperative societies, social welfare, village planning, or any other matter to which the executive power of the state extends. The expression, one inverted comma, or any other matter to which the executive power of the state extends is understood by the is sought to be relied upon to justify the notification dated 25/9/1996 of the Governor of Assam, by which even college education in general had been entrusted to the KAC. Admittedly, the executive power of the state otherwise also extends to the education department, including the higher education department. And if in exercise of the powers under paragraph 6(2) of the 6th schedule to the Constitution of India, the Governor of Assam, in consultation with the district council, had also transferred college education in general as a transferred subject to the KAC, prima facie, it cannot be noticed that entry 23 of the notification dated 29/6/1995 would be without jurisdiction and authority. From such point of view, we do not notice any prima facie case being made out by the petitioner that the additional Director of Education, Karbi Anglong Autonomous Council, did not have the jurisdiction to issue the impugned order dated 3/7/2023, placing the petitioner under suspension. Full stop. Also considering the balance of convenience and the irreparable loss as regards the council on their decision to place the petitioner, Dr. Harve Inti Katharpi, on suspension, we are not inclined to pass an interim order for the present. On the ground that the additional Director of Education, KAC, did not have the jurisdiction to pass the order of suspension. However, as the matter requires a further hearing, list again, day after on Thursday for further hearing on the issue as to whether the additional Director of Education, Karbi Anglong, has or does not have the jurisdiction to pass the order in full.
Item 15.
Mr. Test this order in the division bench. If the division bench takes a different view, we'll follow it. If it accepts the same view, you also make your argument.
As per last order, my lord, your lordship is to ask why.
None appears for the petition at last order.
Before
One before that. Grievance raised is that although he claims to be senior to the fort, the grievance raised by the petitioner is that although he claims
there was no NOC.
why?
But that was the only reason that the
Sorry.
master degree.
Master degree of?
Of the petitioner. He has done his master degree without obtaining NOC from the authorities.
That is.
Yes, Lordship has already.
State, Tembi. Heard Mr. B. Purokastal and counsel for petition, also heard Mr. B. Kaushik and counsel for the respondents in the secondary education department. Where is the order?
Page 55, madam.
Page 55. The order dated 33/2023 of the Director of Secondary Education Assam, allowing the respondent number 4 herein, namely Jiten Chandra Borman, to be the in charge principal of Patrebari Higher Secondary School is assailed. কি বলো? Sentence complete হল না। No, no, sentence start code করেছিল। শেষ হল না। Is a sale on the ground that Jiten Chandra Borman, by virtue of the length of service, is junior to the writ petitioner, and therefore there could not have been any acceptable reason to ignore the senior person and allow the junior person to be the in charge principal. Mr. B. Kaushik, as required by the order dated 18/9/2023, has obtained the information that the respondent number 4 was allowed to be the in charge headmaster inasmuch his MA degree was obtained during his service period without obtaining NOC from the authorities. The said issue is no longer a res integra to the extent that obtaining a degree without obtaining NOC may be a misconduct, but the same will not invalidate the degree which was otherwise obtained from which is otherwise valid in view of the provisions of Section 22 of the UGC Act 1957. Is it 57? 56. 56. In view of above, on a prima facie case being made out by the petitioner, the further operation of the order dated 33/2023 of the Director's shall remain stayed until further orders are notice steps.
Item 17.
Item 17, madam. There is a direction to produce the report.
So rejected by the DLC in a meeting by the same financial comparison records. The records of the DLC is ordered by the, as required by the order 22/9/2023, be produced on the next returnable date. Response.
But they have communicated in 4 weeks time maybe.
Record. Why?
Entire records.
Why?
But they have said
Somebody will be walking with the records. Sorry?
Record is very big.
Very?
Very big matter. Very big.
How does it matter? How we can manage a big record in 4 weeks and not in 4 days?
They have sent a record matter under one carton.
Sorry?
In earlier matter.
No, ask these authorities to behave in a more appropriate manner. Give us the records of the consideration of this man, that's all. It should contain one comparative statement of the financial position of all the applicants. The record will be relevant, will be not more than 1 or 2 pages. How can it be voluminous? And what is this approach of the Deputy Commissioner to avoid producing judgment saying it is voluminous? Do you think that the courts will be threatened by the statement that the record is very voluminous? Please don't call for it.
Even earlier matter, I have already discussed with the office staff, my lord. They have sent the entire record.
Ask them not to send the entire record.
Send the
So why doesn't he send his whole office? He can send the entire records of the entire DC office and then ask the government council, now you find out where the record is. What are they doing there?
They have to make a statement.
Tell the deputy commissioner, only when you have to manufacture record, you need a longer time. When you have to place an existing record, you don't need so much of time. Tell him. Possibly there is no record.
Maybe.
This case, we have some serious doubts on the existing record. That's why we asked a production record. Possibly there is no record. It is stated that the records may be voluminous. We don't understand why the records will be voluminous in as much as the relevant record would be the comparative statement of financial position of the respective candidates were considered in the same DLC, which cannot be understood to be more than a few pages. Placed on so and so. Tell him. What they do, they have not done it. So now they are saying, try to avoid it. Voluminous, this, that.
One cartoon they had sent earlier.
So, or else ask him to send the whole office and also ask them to come along with the records and they will find it out here.
Just ultimate record is
I know.
good, my lord. That is in one cartoon. They have sent the entire.
Tell these persons that we are willing to pass some orders on contempt also, if necessary, if they don't cooperate.
Item 20.
This 20, what is the matter? Yes, madam.
Here we are challenging the appointment of the respondent.
No, why was it adjourned timely?
Lordship, the
Mr. Naik was not there. Huh.
Yes, he was not there. Lordship, we are challenging the appointment of the respondent number 4 as in charge principal of the College of Teacher Education, Mongoldoy. Lordship will kindly peruse.
Teacher education means it is under the SCRT.
Lordship, yes.
SCRT, I think.
There's a separate service rules there, Assam State Education.
On
Research
what
and-
ground you challenge that?
Lordship, basically, main objection is that the person does not belong to the Assam State Council of Education, Research and Training Service. He belongs to the Diet Service. In fact,
There are two different services.
Yes, there are two different services. And this person,
Principal of Mongoldoy College. Mongoldoy College of Education is under SCRT or,
SCRT, College of Teacher Education.
and what
B.Ed
is
college.
Diet?
It's a B.Ed college.
This is a,
B.Ed college, Lordship, yes.
Acha, this is a B.Ed college.
Lordship, yes.
And Diet is a DLED college, I think.
Diet imparts
DLED.
teacher education, yes,
D-
DLED
D-
courses.
DLED, Diploma in
courses.
this thing.
Yes, Lordship, yes. That is a different service altogether. They've got. a
Yes, Mr.
different
Naik, what is your
services.
submission? Does he belong to the SCRT service?
One document from her petition on the lordship,
page-
page 55.
55.
Yes. Page 55. This is a letter written by the association. Lordship, may kindly see serial number
As
1.
deep concern over the matter strongly opposed if Tapan Sharma is allowed to hold the instance after superannuation.
Serial number 1. Mr. Tapan Kumar Sharma is a new incumbent in the College of Teacher Education, CTE Mongoldoy, and he joined 1st September 2017. This is their admission. Now,
very
Lordship will see on which they at page 35, Lordship. Page 35. So he joined as a professor in the Mongoldoy City, Lordship, in the year 2017. Whereas the petitioner is concerned, Lordship,
Just a
will see
minute.
serial number 4.
Just a minute. Recommendation of Public Service Commission, the service of following academic faculties of the are regularized. 4D.
So first was his appointment was on 28/12/2021, regularized in
That regulation is
2023.
of the petitioner, Lordship. The regulation order which your Lordship is perusing in the post of professor, that is of the petitioner. And the list of professors, that does not include the name of the respondent number group, because that is the feeder post from which the post of principal is filled up.
From the post of
Yes,
professor.
from the
Yes.
post of professor. And he is a senior lecturer of Diet. And
No, just a minute. Tapan Sharma, new incumbent in the college, joined on so where is the order of appointment? 2017?
Lordship, that order is not before me
No, okay. Can you produce that order?
Lordship.
Mr. P. Nayak, Land Counsel for the SCRT, refers to the representation of the Assam Government B.Ed College Teachers Forum, wherein in paragraph 1, it is provided that the respondent for Tapan Kumar Sharma is a new incumbent in the College of Teacher Education, Mongoldoi, and he joined on 1/9/2017. The respondents to produce the relevant order by which the respondent for was allowed to join in the College of Teacher Education, Mongoldoi, this day after tomorrow.
There is also one document, if your lordship may kindly peruse, the gradation list of the senior lecturers of DIET, the latest gradation list at page 70, lordship, his name is reflected there. Page 70, this is the notification dated 30 June 2023.
Page 70.
Page 70, 70.
What is this?
This is the notification by which the gradation list, final gradation list of senior lecturers of DIET was published.
What does it contain?
Yes, and the final gradation list of senior lecturers of DIET.
Not senior lecturer, professor.
No, the senior lecturer, lordship. Senior lecturer.
No, we want the list of professors because only professor can become a principal.
I just wanted to show your lordship that his name is reflected in the gradation list of senior lecturers of DIET, showing that he is a member of the DIET service at page 74, lordship,
of
serial
DIET.
number 50. Yes,
So he's still in diet.
still in DIET. Still in DIET. He
That's
cannot
why
be-
tell us the arrangement, how he comes to do the day after tomorrow. Thursday. We want to see how he came into this one.
Lordship.
Item 22.
My mistake.
Mr. N. Ahmed, an Anand Land Council petitioner states that the petitioner does not want to press with this petition in the present form with liberty to file afresh. Pray aloud.
23.
Yes, sir. Unaware of the daily assessment made, the medical. You have it?
Yes.
Give it to him. Pursuant to our order of 6/10/2023, the Education Department has produced the result of the medical examination of the petitioners. Mr. A.R. Bhuyan and counsel for the petitioner may examine the report list on again on so and so. When we can't give you a copy, we examine it, whatever you want to see from there.
We can give the copy also.
You can give it.
I'll provide.
Item 32.
Yes, record them something. Record that here.
Yes.
26.
During this case, what happened? Some rubbers were seized by the custom department. Nobody turned up. Thereafter, lordship acquisition was there. Order of confiscation was passed. Thereafter, the petitioner appeared. And
After confiscation.
then he filed appeal. Appeal was allowed. In the meantime, we auctioned the goods after obtaining the necessary documents.
There was no interim order, nothing.
No.
So auction the goods.
We
Auction the goods.
And we auction the goods as per the certificate provided by the valuer. Now he comes that the market value of the goods was 10,000. It was more than we sold it to rupees 50. And notice was issued to him, but he didn't participate in the auction lot.
He did not participate in the
He
auction.
didn't participate. He approached this honorable court. This honorable court directed the authority to pass necessary order, and we passed the necessary order. That has been challenged now, but auction has not been challenged.
Yes, on what ground you challenge?
Here actually they have seized the goods on the railway platform on the presumption that is the customer good. and subsequently that was seized and order was adjudication. Meanwhile, I appeared before the adjudication authority, before the adjudication of the order to release provisionally. But
While the goods was in existence or it was already
yes, no,
auctioned?
no. When goods are in existence.
Okay, after we appeared, did the authority pass any order in your favor?
No, they,
Did the authority pass any restraint order?
no, nothing. They kept silent.
Then
Thereafter,
No.
adjudicating authority.
you
passed
should,
order.
you should have approached this court at that stage when the authority did not pass any order.
No,
You should have filed a writ petition saying that this is my case.
During those period,
Balance of convenience is such, kindly restrain the auction. We would have passed that order.
actually,
But today, what can we do?
no, actually, the
Today, under the law, if it was a goods which ought not to have been seized or confiscated, you'll get the money of the
Yes,
auction
yes,
money.
yes.
You take that money.
Yes. Actually,
Now,
this is, sir. Actually,
now
value of the goods is,
on the valuation of the goods, if you assail the valuation made by the official valuer, you have to challenge that.
no, actually.
That
we have
time is also over.
We have challenged that. Actually, value of the goods was at the time of seizure 5,68,174. But they
No, no, who had made that valuation? 5
the
lakhs.
department of at the time of seizure.
Where is it? Let
That
us,
is- that is on record.
Huh?
That certificate is on the record. Before
That is on record.
no, let us see what is page number.
Uh,
That the department had valued the goods to be
value
5
the
lakhs.
goods
Where
at
is
the
it?
time of seizure.
Huh? Where is it? Where is the valuation by the department? It is 5 lakhs.
Yes, that is at the time of seizure, that is seizure list.
Yeah,
that is-
let him argue. Mr. Sahu,
Sir, yes, sir. Page number
please give the
16,
answer.
16.
16.
16.
Page number?
Page number 16, 16, annex A.
Page number 16.
One single page.
This is estimated value.
Is that type that is
How do you substantiate it? This is estimated value. This is because, see, when they issue a seizure list, they are bound to put an estimated value, and that is put without any verification, without any valuation. It's a tentative value. So, we'll put a dangerous question to you. If I accept your contention that this is the value to be accepted, I'll also determine the law that the estimated seizure value would be the value of the goods for all time to come, and it will be binding on all the parties. Okay, do you want that judgment? They see, in one matter, we'll direct them to pay you a few lakhs, but tomorrow, whosoever goods are seized, they are going to put the value at 10 rupees. Any goods you seize, estimated value 10 rupees. And that will be the final value. You cannot even challenge it. You cannot put it to a valuer. You cannot put it to. Are you agreeing it?
By that time, I would have raised the objection, this value of the book is.
No, sorry.
Or.
So now also, they have also similarly raised the objection, and therefore to get it verified, they have got it verified through a valuer, which is a acceptable procedure under the law. So when it is in your favor, you accept the estimated to be the final value. When it will be against you, you'll be objecting to it. So double standard cannot be accepted.
Market price at the time.
And mind you, this estimated word itself is estimated. Estimated is never the real value or the evaluated value.
Actually, sir, the department authority after.
Tell us any provision of law that the estimated value at the time of seizure would be binding on the department for all time to come. Produce. The petitioner may produce any relevant provision of law which may show that the estimated value at the time of seizure under section 110 of the Customs Act would be the final value and binding on the authorities without the requirement of any further valuation.
Matter has been settled by the Supreme Court in 1999 ELT Supreme Court.
As per custom manual, before auction, we have to follow some guidelines.
Which paragraph?
Paragraph, paragraph 7 and 9.
Mr. Sahu, why do you underline like this? No, no, if you underline everything, then it's as good as not underlining. When you underline, when you read one or two specific word or one line somewhere, so that immediately your attention goes there. But you underline the entire page, that will be equivalent to it being not underlined. And now only one line is not underlined. Should I consider that to be the highlighted one? Some time back, I was in the bar at that time, I was sitting. One counsel from outside, he has come. And his whole book looked green like this. I was wondering that we all are having black and white books. How this person is having a green color page book. Then it was noticed that every line, every word was underlined. Every line of the book was underlined with these highlighter pens. So that I asked a gentleman, why did you do it? So smiles back and says, of course you have no answer to underline the whole page. Now which paragraph?
7 and 9.
7 and 9. There is a high court order to return the goods. They did not do it. This is number one. And 9, it was a contention of a lawyer. It is contended by Mr. Dave. It's not a finding of the court. So where is the law laid down that the estimated value which is put at the time of seizure is the final and binding on the department? Question to set the binding on the department. List on so and so for the hearing on the issue.
And another part, Calcutta High Court also, there is so many cases also there.
But that will be a dangerous proposition, Mr. Sahu. If you are asking an order from the court that the estimated value should be the final value, from tomorrow they'll start writing 10 rupees and telling you any goods you see is custom 10 rupees. And then refer to Guwahati High Court judgment that this is the final value. Where does it provide that the estimated value is the final?
So that is not the estimated value, the final market value of the prevailing time that is to be taken into consideration. And that is, there is no.
So that stage is over now. Your only argument to be noticed is that estimated value of the season notice is the final value, pay me that at least. Then you have to establish it that it is the final value. We'll pass the order.
Because department is not come any value.
Definitely.
By that time.
They had auction, what can they do? They got a valuer give it that. No one has challenged the valuation by the valuer.
Still not that is not important.
Till now also it is not challenged. If it's challenged, at least we can ask the valuer to tell what ought to have been the correct value.
At this stage, it is more than 10 years after picture of the good.
Then the next question to Mr. Sahu, why is this petition kept pending for 6 years now? You have caused a further damage to yourself.
But this is the first time I have to carry, second time.
What's that?
Initially, there was a
I think there is a system called mention at 10:30. Everybody gives one memo. That was not a event.
Based on that, the case may be disposed.
You be happy what was the auction money you paid him.
We have already offered him. Order was also.
Only 1,50,000. They are paying 1,50,000.
That you are entitled. But otherwise, how do you
very loser to the. Actually, I have not committed any mistake, any wrong. But
Mr. Sahu, we are not here to protect businesses. We are here to protect the law.
Yes.
That's all.
So actually, this will petition should not be loser.
How can you determine you are loser or not? Where is the material? It is your perception. Perception is not a material for a court.